ಎಲ್ಲರಿಗೂ ಶುಭ ಸಂಜೆ. ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು ಹಾಗೂ KSBC ಲಾ ಅಕಾಡೆಮಿ ಇವರು ನಡೆಸಿಕೊಡುತ್ತಿರುವ ಉಪನ್ಯಾಸ ಮಾಲಿಕೆ ನೆನಪಿನ ಉಪನ್ಯಾಸ ಮಾಲಿಕೆಗೆ ತಮ್ಮ ಎಲ್ಲರಿಗೂ ಸ್ವಾಗತ. ಬೆಳಕು ಕಾರ್ಯಕ್ರಮದ ಉದ್ದೇಶ ಏನೆಂದರೆ ವಕೀಲರ ಸಮುದಾಯಕ್ಕೆ, ವಕೀಲ ವೃತ್ತಿಗೆ ಅಪಾರ ಕೊಡುಗೆಯನ್ನು ನೀಡಿ ತಮ್ಮ ಜೀವನ ಪರ್ಯಂತ ನ್ಯಾಯಾಂಗಕ್ಕೆ ಮತ್ತು ವಕೀಲ ವೃತ್ತಿಗೆ ತಮ್ಮ ಅಮೋಘವಾದಂಥ ಸೇವೆಯನ್ನು ಸಲ್ಲಿಸಿ ಕಾಲ ಗರ್ಭದಲ್ಲಿ ಲೀನವಾದಂತಹ ಮಹಾನ್ ವ್ಯಕ್ತಿಗಳ ನೆನಪಿಗೋಸ್ಕರ ನಾವು ಉಪನ್ಯಾಸ ಕಾರ್ಯಕ್ರಮವನ್ನ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ ಲಾ ಅಕಾಡೆಮಿ ಮೂಲಕ ನಡೆಸಿಕೊಳ್ಳುತ್ತಿದ್ದೇವೆ. ಇದುವರೆಗೂ ಹಲವಾರು ನೆನಪಿನ ಉಪನ್ಯಾಸ ಕಾರ್ಯಕ್ರಮಗಳನ್ನ ನೀವು ಈಗಾಗಲೇ ಮಾಡಿದ್ದೇವೆ. ಇಂದಿನ ಉಪನ್ಯಾಸ ಕಾರ್ಯಕ್ರಮದ ಕೇಂದ್ರ ಬಿಂದು ಅಂದರೆ ಹೆಸರಾಂತ ವಕೀಲ ಹಾಗೂ ಹಲವಾರು ವಕೀಲರಿಗೆ ಮಾರ್ಗದರ್ಶನವನ್ನ ನೀಡಿದಂತ ಶ್ರೀ CB ಮೊಟಯ್ಯ ಇವರು. ಇವರ ಬಗ್ಗೆ ಮಾತನಾಡಲು ಹಾಗೂ ಇವತ್ತಿನ ಉಪನ್ಯಾಸ ಕಾರ್ಯಕ್ರಮವನ್ನು ನೀಡಲು ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಹಿರಿಯ ವಕೀಲರಾದಂತ ಶ್ರೀ SP ಕುಲಕರ್ಣಿ ಅವರು ಬಂದಿದ್ದಾರೆ. ತಮಗೆ ಸ್ವಾಗತ ಸರ್. ಶ್ರೀ ಮೊಟಯ್ಯ ಅವರ ಬಗ್ಗೆ ಅವರ ಮೊದಲನೆಯ ಕಿರಿಯ ವಕೀಲರಾದಂತ ಅಂದ್ರೆ ಜೂನಿಯರ್ ವಕೀಲರಾದಂತ ಹಾಗೂ ಕರ್ನಾಟಕ ರಾಜ್ಯದ ಮಾಜಿ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ಶ್ರೀ ಉದಯ ಹೊಳ್ಳವರವರು 2 ಮಾತುಗಳನ್ನ ಹಾಡಿದ್ದಾರೆ. ಆ ವಿಡಿಯೋ ಚಿತ್ರೀಕರಣವನ್ನ ತಮ್ಮ ಮುಂದೆ ಇವಾಗ ನಾನು ಇಡ್ತಾ ಇದ್ದೇನೆ. ಅದು ಸ್ವಲ್ಪ ಮೆಮೊರಿ ಕಡಿಮೆ ಇರೋದ್ರಿಂದ ಮಧ್ಯದಲ್ಲಿ ಸ್ವಲ್ಪ ಅದು ಅಂತ್ಯಗೊಳ್ಳುತ್ತದೆ. ಆದ್ರೂ ಕೂಡ ಅವ್ರು ಹೇಳಿದ ಮಾತುಗಳನ್ನ ಕೇಳಿಸ್ಕೊಳ್ಳೋಣ.
Friends, Sri CB Motaiah was one of the tallest of lawyers on the criminal side of the Bangalore bar. I had the privilege of being his junior. Immediately after enrollment, I joined his office. I was with him for about 7 months, after which I started independent practice on my own. He was very meticulous in his habits and professional career. He had a very incisive mind and was a brilliant cross-examiner. During the 70s, there was a sensational murder case known as the Mahalakshmi Layout murder case, and Sri CB Motaiah appeared on behalf of the accused. The trial was reported on a daily basis in the newspapers, and virtually the whole of Bangalore was reading the said news report because of the brilliant performance and cross-examination by Sri CB Motaiah. He had a beautiful handwriting. He would make his own notes in his own hand, and when one read
ಮೆಮೊರಿ ಅಭಾವದಿಂದ ಶ್ರೀ ಉದಯಳ್ಳವರ ಚಿತ್ರೀಕರಣ ಅಲ್ಲಿಗೆ ಅಂತ್ಯಗೊಂಡಿದೆ. ಈಗ ಶ್ರೀ SP ಕುಲಕರ್ಣಿ ಹಿರಿಯ ವಕೀಲರು ಇವರನ್ನ ಇಂದಿನ ಉಪನ್ಯಾಸ ನೀಡಲು ಕೇಳ್ಕೊಂತ ಇದ್ದೇನೆ. ಶ್ರೀ ಕುಲಕರ್ಣಿ ಸರ್.
Friends, I feel I am
ವಿಡಿಯೋ ಆನ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್.
ಸ್ಟಾಪ್ ಮಾಡಿದ್ರು. ಯಾವ ಸ್ಟಾಪ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಿ ಕಣ್ ಪೋಸ್ಟ್ ಸ್ಟಾಪ್ ಅಂತ ಬರ್ತದೆ. ಸರ್ ಬಸವರಾಜ್ ಸರ್. Basavaraj sir, host has stopped ಅಂತ ಬರ್ತಾ ಇದೆ ವಿಡಿಯೋ. Friends, at the outset, I'm extremely very happy that Basavaraj has ಕೇಳ್ತಾ ಇದಲ್ಲ ಸಾಹೇಬ್ರೆ? Hello?
Yes, sir. Yes, sir. Yes, sir. Yes, sir.
Very, thank you, sir. Thank you. I'm extremely happy that Basavaraj the Great has just provided me an opportunity to utter few words regarding section 482. That is the first thing. I should greet him and thank him for that. And above all, friends, we have got to recollect Mr. C.B. Motaiah today, a great senior lawyer, eminent lawyer, as just now informed by Sri Udayawalla Sahib. Friends, even a few words about him is, I have listened to about his character from Mr. Chandramouli, former state PP, and Udayawalla Sahib, former Advocate General, Senior Counsel. They went on so many words about him. He was very sincere lawyer, first thing. His behavior in the court was excellent. He never eroded in the court. He was so silent. His voice, even whether it was heard by the judge or not, but he used to get relief. Excellent man. Even his performance, character, distinguished reputation, his behavior with parties, his behavior with young lawyers, all are guidelines for young lawyers. That is why Basavaraj chosen Motaiah Sahib's to be done here. I'm very happy. Anyway, we have got to say that his quality should prevail further. We can't forget about him. He might not be here, but his qualities, his character, his footsteps should be followed by young lawyers. With these words, I'll start my lecture. Friends, Halla Sahib added the word cross-examination. First cross-examination was excellent. Hiregowda, the great lawyer of Northern Karnataka, used to say cross-examination is a double-edged weapon. More you ask, more you lose. Halla Sahib also told me Motaiah was very short in his cross-examination, but very meticulous. Anyway, with that, I shall start the subject. Friends, today's subject is section 482 of Criminal Procedure Code, inherent powers of the High Court. To read, friends, section is very short, very small, contains only 4 lines. If I am to read section 482 says, saving inherent powers of High Court, nothing in this code shall be deemed to limit or affect inherent powers of the High Court to make such orders as may be necessary to give effect to any order under this code or to prevent abuse of process of any court or otherwise secure the ends of justice. Friends, the section starts with the word nothing in this code shall deem to limit, as if it is larger. But judges and courts, so to say, have made it shorter or narrower by saying only in extreme cases or deserving cases or channel cases, only 482 can be used. That is the first impression that all of us have. Then, friends, to go with section 482, we have got to presume, we have got to know that by reading 482, we can't go because CRPC again has to be read. Elementary principle of CRPC, elementary principle of IPC, definitions, exceptions, all of them should be read together because, for example, I will just quote an example in the beginning. Most of the cases are entertained. Several cases are entertained by Honorable High Court under section 482 for the first ground that the complaint or FIR does not contain essential ingredients of the section alleged. Friends, if we do not know the sections of Indian Penal Code, we can't jump to the conclusion of 482, which means to say we have got to know again general principles of Indian Penal Code. First lesson is the general definitions. For example, dishonest intention. One of the latest Supreme Court has said dishonest intention should be right from inception, not later. Vesa Holdings case, right, is 482 case itself. Supreme Court says that dishonest intention, if it is brought out later, you can't hold him for that section at all for 420 because it should be there for right from beginning, what you call as from the inception itself. For that, we all of us need again go to Penal Code definition dishonesty. So what is dishonesty? Making wrongful gain to himself, wrongful loss to the other. What is fraudulently? A man is said to do a thing fraudulently who does that thing with an intent to defraud, but not otherwise. Defraud means to deceit and injury. Injury is nothing but harm done to your mind, body, and reputation and property. Friends, these definitions, again, I am insisting that unless you know the basic definitions, we will not be able to go at 482, because all done in court halls in 482 is, what is your case? Please read your complaint. Friends, when you go to court, court will say, please read your complaint. Then we have got to say that it does not contain ingredient, it does not reflect the allegations, and it is only a mere for the purpose of lodging a complaint he has done it, then we will be succeeded. Therefore, first endeavor is, friends, we have all, as young lawyers or friends, whatever it is, we have got to presume, we have got to think that Indian Penal Code provisions of general definitions, general exceptions, and all provisions of IPC plus CRPC also have got to read, because, for example, if a complaint is lodged delayedly for 10 years after, then limitation comes 463, 468 of whether magistrate can take cognizance. Then again comes up the question of limitation, because no court shall take cognizance unless it is within the period of limitation, whatever it is. Therefore, my first endeavor to all our young friends is, please go through provisions of Indian Penal Code, CRPC, then come to 4. That's one aspect. Then, friends, we shall go to the next stage. What is meant by these words, or the two sections, or the bare section says that nothing shall lead to limit or affect the inherent purpose of the court, so as to make order as may be necessary under this code to prevent the abuse of process of court or to secure ends of justice. Then comes up, friends, number of judgments of Supreme Court as well as High Court have interpreted provision, the abuse of process of court. What do you mean by that? When we file, normally we all say, in a good sense, we all say a 482 petition, because the concept is, because we are cautious, because unless we have got to know the basic things in that case, or basic things of CRPC, IPC, we will not be able to get the relief at all, because first question by the court will be, what is your case? What elements they have you got essential ingredients? Or is it bar? Is it limitation bar? Is he not competent to lodge complaint? Or abuse of whatever it is. Therefore, all these concepts, one of the other, come under the definition of the abuse of process of court. For example, if a complaint is lodged beyond limitation, you can't ask the party to go on as an accused, joining his hands in the court for years to get 10 years when the trial comes. Instead, if you file 482 before Honorable High Court, if the Honorable High Court is able to gaze that it is time barred, so no court will take cognizance. Court has already taken cognizance, then the High Court quashes the order. Most of the cases under section 200, you see, all of us know, learned magistrate takes cognizance, issues process, whatever it is. Against that, we will filing. Supreme Court has held to file a revision also. Some judges, the Supreme Court has divided again, even as on today, revision would also lie, criminal petition would also lie. If you ask for quashing the proceedings, 482 comes. If you ask for quashing the order, revision comes. All those things are again there. But above all, we have got to find out and check up whether basically case can be thrown or toppled. That is the basic principle of 482. Either person, for example, any number, recently came across a case, a notary's act. A notary has halted for doing something. He said, sir, that fellow, the person whose affidavit has been shown to before they to notary, that fellow was not there, he was in Bombay. It's already recently conducted case. Then the question was, then it came up, and first point, section 13 says, unless the complaint is lodged by a competent person, because the one who has got allegation, one who has got complaint has to lodge a complaint to authority. Authority should lodge a complaint. On that ground, this Honorable High Court, Justice Nagpur quashed it on the ground that maybe the allegation, but what is it? The procedure is, unless the competent person files the complaint and takes it to the file, case cannot be lodged. That is one of the aspects. Secondly, limitation may be there. Then the minimum things may not be there. Then the court may not be having jurisdiction. So all these aspects are put together one after the other. That only frames what you call as 482, and there is no end to this section at all. It goes up day by day, day by day, day by day. But there are cases wherein this Honorable Court, I have got experience, a person sitting in states of America, USA, is said to have caused, ill treatment to a lady in India. Court says he can be halted, nothing, because it goes, it's not as if he has to personally present. Even words uttered, messages sent, email sent can also amount to that. Therefore, our endeavor is, to what extent this 482 would go all the way to end? It's all experience of the court. It is the feeling of the court. It is the magnanimity of the court. It is called wisdom of the court, or propriety of the court would be the last. Then comes up, we'll say, when such orders may be necessary, it depends. We can't say this court might have done, this court might have allowed, might not have allowed. That is not the concept at all. It is all is the judge's framework. Then can we say, can we say then, can we equate court with the judge or judge with the court? Then the question comes, friends, court is a systematic institution where we will be able to file within the corners of the court. But judge has to feel by himself whether 482 can be entertained or he would be left to do whatever it is. Notwithstanding that several big, beautiful cases are there, courts may not entertain because he has got complainant, has got other hurdles in him because he already filed a suit. In a case, a number of cases have been reported, I have flagged here, where a civil dispute is involved, 482 not entertained at all. They say, what you can't do in civil court, you want to do it welcome. Therefore, court would not enter because that amounts to abuse of process of court. You want to take disadvantage of situation because you want to see to it that you are remedy through the criminal because you are not able to get it. Right from 1985, Supreme Court has said wherever civil litigations are there, whether civil decrees are there, civil judgments are there, don't entertain court because it is got a double-edged weapon, one cannot face it. Then comes up, friends, secure the ends of justice. What do you mean by that? Secure the ends of justice means last fag end of a situation where you see court is cornered as to what to do in that case. Number of cases of that type has come. In a case, in a situation where Justice Venugopal was sitting, very excellent cases, very large number of parties were very much there. It is a matrimonial dispute. The judge could only say, he advised the parties, you do one thing, your dispute or whatever it is there is not very much large. There is only a small misunderstanding. If you want to see to it that your family is remedied, your family wants a protection with the child, go together. I will spend for the hotel. Please go right now. That was the expression of the judge, and later on it all negotiated. It went to the chambers. Your lordship advised. Then they got success. They went there. They are very happy. Then after 2 years, they write me. They listen. There's I have got another child, sir. Very good, very happy. So question is to secure the ends of justice. Court, it's not as if court should pass orders only. Judge can go step ahead and say, no, get it settled. Because some things you see human, though judges are expected to interpret propositions of law, judges are also human beings first. Either you are a lawyer or prosecutor or judge, whatever it is, humanity can't be forgotten because first you are human beings, then go to law. His lordship said, and then thereafter, after a few years, lordship said, we are happy and both the lawyers have joined and family has been, put in a very high situation. They are very happy with a new child born. Therefore, my endeavor is all these situations, keeping apart the provisions and all that, court concept or court magnanimity or majesty of the court is very, very important one. Then comes, friends, meaning of the word question. What do you mean by question? Question means it throws away, it washes the whole thing. That is the expression used. But it does not end in itself. In some cases, Supreme Court or High Court, either quashes or partly quashes. No, you do, I will do one thing. Issuing process, I'll do it. I'll set aside. Let the complaint remain and go back. It is not as if section 482 is always meant for questioning the whole process. No. You can also set aside or set. Number of matters are like the even bail section. Sometimes in a bail, a wrong condition is very high condition is levied. If the court may say, no, I will reduce, I will modify the condition, not the bail. So therefore, these are various facets and various ways in which courts take its life proposition. Court said in a recent case, Justice, I believe, Motaiah in his days said, there is no end, there is no equality, there is no ratio in criminal law. It's all experience because one case does not depend upon the other. And it's not as if all the witness to a case will not see in a different, they all see the different angles, one educated man, an old man, a young man, they have their own story to tell. Therefore, lordship said, in a criminal case, there is no ratio decidendi, except the expression of the judge or human mind of the judge is answered by. That's it, perfect. Then comes up, friends, though the section reads in a positive form, I am again repeating, section says nothing shall limit. It means limit is larger, boundaries are larger. But what is happening is courts normally say, sir, you have come to us before 482. Why should you cash? Why don't you go and take discharge or ultimately fight the litigation? All that is the first formula. Their expression, if all the cases of this type are stayed or quashed here, what business the magistrate has to do? Because truth alone, truth should prevail. Truth should come out only by trial. There are several intricate, complicated issues. For example, they will not be entertained. They also, no, go and urge their own. Except that it can be quashed on a technical ground, jurisdictional errors, or without jurisdiction, without the authority law, limitation, not competent, totally abuse of process law, any manifest. That is why Bhajan Lal again remembers, Bhajan Lal remains 1990 Supreme Court even till day, notwithstanding that several judgments have come out, even little contrary to the judgment, but Bhajan Lal remains. Section 108, I'll come to that later. Para 108 of Bhajan Lal says, what are the grounds on which the Supreme Court, the High Court would entertain Section 4. Then comes the friends, in a recent case, Sunil Kumar's case, 2022-2, part 1837, he lost Chief Justice Nagaprasanna Sahib has gone into very details, enumerating about, referring to about 13 to 14 judgments. He says, you see, until he also, learned judge says, Supreme Court judgments, as many as 10 Supreme Court judgments are referred to, but still the judge says abuse of process of court should be felt by the judge himself, whether it can be retained or thrown. You can't be civil disputes, this, that, the section 420 was there, 3043. He says, I can't independently, SC/STs Act. He said, I can't independently go into all that, but overall situation is, if you are giving it, give, otherwise forget. Then friends, what is the stage at which 482 can be filed or quashed? It goes on different. For example, one files a complaint under section 200 before learned magistrate. Learned magistrate takes cognizance or issues process. Against that, 482 can be filed. Or a complaint, even before issue, when a complaint is filed, a FIR is registered. At that stage also, 482 can be filed. Then after a charge framed, 482 can be filed, unless there is an appeal or revision under there. We all of us, we can't forget, if there is any alternative remedy, no 482. It's not for a fashion sake we're doing. Extraordinary power, because if anything lies, no 482. There is no doubt about it. Then what? Then in quashing only, then you may also ask, sir, can quashing be done only for one man and leave the other? Exactly. Supposing in 498 a section is there, ill treatment or whatever it is, abusing or whatever, troubling her, torturing the wife by the husband or his relatives is the expression. Rameshwar State, we argued a case in a very thrilled manner. One fellow was involved throughout, he was not the relative. Question came, then High Court said, no, we know all that, but he's not the relative, we don't entertain. They dismissed it. Therefore, the question here was, if a relative, for example, for a husband, they may not say, no, we don't entertain so far as husband is concerned. We'll do it only for the old parents or in-laws or whatever it is you want, you can question it, depending upon what the elements or whatever allegations are there. Therefore, it is like a partial quashing. And they will also say quashing of these will not come in the way of husbands, whatever it is. Then 319 comes. Even later also, we can get them again under 319 of CRPC. Therefore, the color of 482 is very flagrant. You see, it goes with different context of judges' mentality or whatever it is, judges' temperament, concept, court's decision, Supreme Court, number of factors would work around that. Then comes, friends, is there a bar for using 482? Yes. Statutory other remedies, there is 100% bar, it will not be accepted. For example, appeal. You may say, for example, there is some conviction or whatever is there. They say, sir, basically, judge would not have entertained this. I want to file for it. No. They say, if an appeal lies, nothing for it. You please exhaust the immediate count. Suppose in an appeal, there is an interim order against that event. That again comes up with 482. Revision. You know, friends, in an appeal, an appellate criminal courts and sit as well as a trial court judge, and he does whatever he like, or what power, right from day complaint to down to judgment. But in a revision, no. In a revision, if it is only jurisdictional error, he has no power at all. Technical aspect, incompetent, court can question, or impropriety, court can set us and send us back. But in 482, all the things are done subject to the availability of alternatives. You may also ask what happens in a bail also. For example, even in a bail, Supreme Court says under 482, indirectly bail can be granted. Though the Supreme Court again has said it can't be. Bail, normally what happens is either anticipatory bail or regular bail. Bail courts entertain the situation or reject it, whatever it is. Against that, if you go to the highest court or under 482, For example, some conditions, whatever it is, recalling at all. Supreme Court says even under 482 by admitting a petition and granting bail, you're absolutely what is granted under 482 is giving him the bail indirectly. Then friends next comes is under 482, ಒಂದು Hawk system and JACO air companies and the latest judgment of justice. It's a very interesting topic. All of us know 362 of CRPC because very interesting, it comes up in 482 number of times. 362 says no court shall alter, correct or modify the final order passed by it after it is signed. It is passed and signed. Very good. There is an end. Forget, don't do, because don't review. This is criminal court, not civil. But Supreme Court in the latest case, thereafter Justice Nagpur follows and says, even 362 dismissed for default. Case was dismissed, none appears, dismissed for default. Only expression, none appears, twice called, dismissed. Against that, the other side filed, sir, recall, please recall it. So earlier you used to get it also recalled. They say it is not an order on minutes. Except clerical, mathematical, whatever expression is there, we don't, please let us recall and you know, Ega, now his worship has said 362 again comes in the way because it is a final order passed. No modification. But I believe must have been taken. So whatever it is, but a learned judge follows the other judgments of Supreme Court and says even 362 is a bar for operating, even recalling the dismissed parties. See the height of situation where it comes up. But 362 has got several angles. You know, the number of judgments are come on that. If the judge has passed the order on his own occasion or whatever it is, mental application of mind or some order is there, he can't recall it, he can't review it, he can't reopen it. There is any number of judgments have come. But now this judgment says that is reported recently in 2022, that is the Hawk system and Xerox case. And Bardidare, the lordship says even that also cannot be done. The only remedy is go to next court and get it restored. Very good. That is the, therefore, we know where 482 would end and where it would lose. We will not know. It is all the experience of a judge and nothing else. Then comes, friends, can there be even, I'm just speaking about bail again and 432 or 439. Bails are being granted or rejected by the courts. On their own occasion, court will say, no, this is there, that is there. You are not produced all that. The essential ingredients are not there. And you are likely to leave this, that goes on. 439 especially, regular bail is granted. Conditions are there. Those conditions can be questioned under 482 because even Supreme Court says, can the High Court grant bail under 482? Was the question answer. Question said, it can be indirect, nothing can be done. Then review of a judgment is the answer. And again, review is again, I'm explaining in view of that 362 on the latest judgment. Of course, even otherwise also, no court can review. And against that, 482 also does not lie because it is nothing like, it is again abusing process, what call it. Then 482, can it be operated or exercised by the subordinate courts is the question. No. In a recent case that is very extraordinary power, Supreme Court says, word used is High Court. High Court saying nothing in this shall be deemed to limit the power. So the High Court is the expression used. Trial court has no power. One judge of from I think Kolar, I don't remember, that case came up. I do not know whether reported that the lordship said no, we are very strict on that because only High Court has got inherent power, not otherwise. Therefore, even what I call as advancing the case was the question involved. He filed a case before High Court. Court said no, the judge is right. He would not exercise, and we exercise a different issue. We do it or we may not do it. But trial court has no power is the answer. Then comes at what stage I am telling you proper or improper. Stages are different, friend. In a case you can't recommend. I remember in a case where trial has commenced, trial has progressed. PW 9th tanka bandiದೆ criminal case, sessions case. Time alli court quashed it on a different ground. That's no, nothing lies. We have gone through because after that there is a tangle period of 4.5 months in a sessions case. High Court took the view. What is this you are doing? See, after 4.5 months, it's not progress, whatever it is, whatever may be the. Then they read the evidence of PW1, PW4 and all that. They said nothing lies, nothing lies. They say it's not possible. Of course, accused person may be great or may not. That you have argued would not answer. But the question is, it can't be kept like sessions case can't be thrown for 5 months. They quashed it on even at the stage when the PW9 evidence was over. Therefore, what stage 482 could be exercised again goes on. different facts of circumstance of each case. Yesterday, we file cases, our experience. Judge says, notice, no interim order. What can be done? We say, okay, sir, that's all. But thereafter, something happens there. He goes further. Then, sir, charge sheet is already filed charge sheet. Either you amend, some judges allow us to amend, some judges, no, you file a separate, permit you to liberate. Therefore, at what stage it can be done? Again, it's an experience, and it goes on different facts and circumstances of the case is one aspect. Then, friends, what are the conditions to apply jurisdiction to High Court? Conditions, what conditions we have to have? One is you can't come all the way 5 years or 4 years. At the inception, in the sense, you see, most of the cases are, in the sense, before progress or trial, whatever it is, either cognizance or FIR state. One is don't come very late. FIR lodged in so and so, after 4 years they come. I have even, we have got experience, several judges tell, that's correct. Because 482 is a speedy power, extraordinary power lying with the court to give justice. But if you come after 4 years, 5 years, even for an FIR, not knowing as to what has happened there, court would not entertain. No, we don't entertain because it is not a fashion sake we are doing it with an extraordinary power. Therefore, we don't. That I think would be the ways of. Then can the court mold and shape the punishment even under? Very good. That can be done. We all of us know several experiences. You see, in a sessions case, murder case, 10 years imprisonment, life imprisonment. After 4 years, 5 years, 6 years, our good behavior, court can, you see, it depends upon the case circumstance. Punishment mold and shape chances even under 482. There is a chance that on a special application thing. There are cases for and against, but it all goes again the experience of judge and all that. Then comes to what do you mean by rarest of rare cases? Supreme Court in a number of cases said rarest of rare cases. They say before entertaining 482 petition, be careful. Because there's some of the cases are so complicated issues, such complicated issues, they have to be tried before the trial court. You see, what answer court would they give? That answer we can't give in the 482 at all. I remember an instance where a doctor was halted for exercising what you call as this anesthesia for applying anesthesia for a patient. Patient dies. 304 OB and adiyalla hakkondu bandru. Then the court said, no. You see, 482 very difficult, sir, because what type of medication is required? What is the period required? What type of operation? How many days he did it? How much period? No, that you see, that exercise, you see, you can't do all that. Mathematics, we are not mathematicians here. Now we are doctors. Even Xavier's case, we can't say, we can't sit and say, what is the quantity of we don't do that. So therefore, wherever meticulous interpretation and of reading tax are concerned, complicated issues are involved, court may not enter. No, we don't do that, sir. They will say, no, 482 is not for fashion sake. Unless there is a legal express bar or something, something should stare on the face. Otherwise, we don't do it. That is one expression. Then therefore, but whatever it is, Supreme Court again has said, rarest of rare case on the expression. No. Question is whether has remained the same or is mounted. Of course, rarest of rare cases is being used. Still, the number of cases are being allowed. It's not as if maybe, but the question is, it again goes on circumstances. Either section for heinous offense, they all go judges' experiences. They say we can't make mathematics or a column. No, this. No. Sections and judgments are there, even including Bhajan Lal. Maybe may not be again goes in the hands of a judge. We can't make a fashion here to say no chart I court put it. We don't do that. Complicated issue, compulsory or court trial court. Unless there is a legal. That is all that aspect. Then comes of friends, quash or compromise or compound like 306 case Monday, Justice Indira Banerjee, Madam Judge, in Usha Chakravarti case, an excellent case. It is not the experience of a judge. In that case, 306 is involved. Person responsible for the committing suicide by person. About 4 to 5 accused persons may be there. Matter came up and a complaint was lodged. Something was going on in between. Thereafter, 488 petition filed before Gujarat High Court. Learned judge goes into details, and both the parties together join and say, sir, we have compromised the issue, everything else for a single piece, PAC piece we want. It was recorded, it was dropped as being compromised. But one of the persons who has suffered because of the incident again moves to Supreme Court, plus sumo petitions are also filed, 4 or 5 petitions are clubbed, and large number of matters are dragged together. The argument was, can the court, was the court right in holding that it is compromised? The argument placed by prosecution side and the complaint side was, sir, an offense of 306 or 307 should not be compromised because it is not the purpose of that case. We are seeing that lady has suffered, her wife has suffered, and that cannot be taken away by your compromise. Compromise may be money side, you might have done, but they say under a FIR under 306 of IPC cannot even be questioned on the basis of any financial settlement with the informant and the word used. They also went to extent of saying 307 Torshidar, 302nd section refer madi, Justice Indra Banerjee, Madam Judge, and we Ramasubramanian Judge, they said, we set aside the compromise and sent. See the height of but the argument placed was, sir, under 482 to secure the ends of justice, he might have done. No, he said, might be. But in this case, very hard case, she is not satisfied. She might have, you see, party might have compromised for the financial issues yet another thing. There is no financial distress anta view kotidare. High Court judge says it is or a caregiver, spouse, parents, all of them joined is the answer given by the learned judge before the High Court. But Supreme Court says, no, we don't entertain. They allowed the petition and they said set aside and send it back to trial. We don't emphasize it as expediency. See that? Then how to emphasize 482? That is why we say it is an experience of a judge and against the order of High Court on 482. Supreme Court always is got wisdom. We know an Article 142 of the Constitution of India, law laid down the Supreme Court is not only binding on the High Court, trial court, this court, party, everybody, even the party that is also gone to Supreme Court. Law declared the Supreme Court is a precedent made and none can question. But it is a law laid down. Then comes a friends, power of the apex court to check up. That's what I'm filtering for. How about Supreme Court's power to check up the order passed by the High Court and the 482 is yet a very interesting. I quoted it. Number of matters. Even Bhajan Lal, for example, Bhajan Lal history, if you take up, it is a very large history. It is not as if one day that the law has been laid down. That is why Bhajan Lal, they say 1, 2, 3, 4, 5, 6, 7, page for 108, para 108. They say you can't take for a fashion. Unless they say his expression under, what you call as those seven things or what he has made 1992 Supreme Court, SC 604 State of Haryana versus Bhajan Law. 7 guidelines have been issued. All of us are bound to know. This is a Magna Carta or what you call as Mahabharata Ramayana of CRPC 482 is a very landmark judgment, and it was the effect of that. Even we have seen even larger judgments come even little contrary. But they have not escaped the what you call as clutches of this judgment. All of us know. He has given a check for that, saying FIR complete reading face value must constitute. Remember, bare reading of the complaint should disclose or make whatever it is some offense or on the face value as it is read on its face value. This is. Secondly, FIR complaint any material whether constitute cognizable offense for the investigation 155 and 156. Then it is FIR bar complaint material collected of you did make any offense. Then forth comes FIR bar complaint of non-cognizable offense, no investigation by police without the permission of the court. Then comes up what you call as inherent force. Then FIR bar complaint, absurd and improbable, no prudent man would go to say that is an offense. Anyone standing on the tree, anyone standing below the sky would say, sir, this would not have, how can it do? Can we expect this to happen? No, that is one aspect of that. The second is, there is a legal express bar against that. For example, no court shall take cognizance unless sanction is there. There is a bar. There is a legal bar. Complaint should be a particular person. For example, Essential Commodities Act and the Essential Commodities Act, they have made one new 2016 government order. So I am luckily it's little work I have on that subject. They say clause 19 says informant yarra helirbahudu, but complaint shall be lodged before the police or whatever authorities by a particular persons. Number 1, deputy commissioner or assistant commissioner, tahsildar, hood inspector, revenue inspector, like that. Like that means not the last. It is not n number. It is numbered. There is nothing like and no other person. On that ground, we have secured. We have got success. In some cases, they say no. Police have lodged. Police cannot lodge the complaint at all. In one case, Rakshana Vediki head has lodge the complaint. Court said, no, we can't do it because whatever it is, the complaint cannot be lodged. He has no business to do it. So therefore, these are the last is if FIR is manifestly attended to, deliberately. Manifestly attended to means deliberately they will only to harass and nothing else. So if any one of these things are found in any one case, the court says you may do it under 482. You may entertain the petition, allow it to enter the gates of High Court, grant an interim order, thereof decide on whatever it is. But it's not an end in itself. These 7 guidelines are not an end in itself because number of things have come up nowadays. Very, very fashionably law is changed because present situation is like that. New offense. Who would know that what you call as new offenses? Very, you see these check cases, other problems. They were not earlier. They are coming up one after the other. So therefore, as and where the law grows or facts grow, law also goes. Interpretation by the courts would also. Then, friends, yet another next important time to proceed is if I'm repeating again, if a matter is dismissed for default, later judgment says you can't restore it, but subject to whatever it is. Then if disputed facts cannot be gone into one matter, then what is meant by disputed facts? For example, he narrates like this way, this has happened, this happened, there is an order passed by them. So the other side were to say, sir, this has not been passed by the authority at all. There is no fangle at all. He has not filed the petition at all before. If these things are there, court would say, we can't go to interpretation all this and it's not proper on our part to go for 482. Only on admitted facts, if it is, we'll do it. Otherwise, no. So complicated issue of facts will not be entered in one of the aspects. Then can the High Court oversee the existing situation and act upon? Maybe. Court would also say, court, on the one side there are facts, on the other side there is law. It goes on how the judge interprets. It is his wisdom, his propriety, his caliber, his majesty will work, because it's not as judge says, every court is a judge and every judge is a court in one of the judgments, Supreme Court has said. Because there is no judge unless there is a human element is involved. No man can be there. But at the same time, if the law says, if the mandatory law says complaint shall be by some person, whatever it happened, is it to the naked eyes, we can't appreciate because law is very extreme on that side. Then comes up, friends, can an interim orders be disturbed by the High Court under 482? Very good question it is. Trial court passes an order, an appeal is admitted, criminal appeal is admitted, sentence is not stayed. No, we are not going to stay the sentence because we know several judgments. Against that, you may come up in 482. You can emphasize with the High Court judges and say, sir, appeal is admitted. It requires large number of years, number of years to come up for hearing, and he is in the jail. He was in bail before the before the trial. In the trial, he had the bail. Now, after conviction, learned judge dissent. They will say, okay, that aspect you see. Therefore, High Court would always, every case, according to us, our experience is, whatever case comes up before the judge, comes up for the first time on the situation, you have come to a real situation, because every case, you see, an excellent or a good lawyer, whatever it is, sane lawyer or college, he finds out a point which judge would not easily throw it away. No, I see, this is there. Then it has to be heard. That's what judges should, feeling should be that is the endure of a criminal lawyer, as we have found. That is what we found in the Motaiah also, according to their expression. I remember an instance, I was very young then, Motaiah was arguing a case, I can't just forget it, in a division bench matter. The paper book was around 278 pages. I thought when this lawyer comes up, he may argue for days together. No, he did not do. He opened the small sheet of notes. He gave 7 to 8 dates, some points. Within 10 minutes, judges said, ask the question. He said, sir, I was knowing that your lordship would ask the question. Page 271, sir. 271 he opened, the judge opened. Then next, sir, 278 page, sir. Then 104, sir. Judge said, okay, allowed. How the height of, you see, they say, for a judge to, linger on any side, or judge to think himself, I am the judge here, I am the judge here, I am the judge here. Tell me what it is. If the judge's experience or judge's desire, judge's thoughts, they are very important. And the judge feels, in a criminal case, what is required? Technicality. All of us know Friends, we all of us know number of things in a criminal concept. We don't appreciate the facts. The trial judges are blamed only for procedure, not for the opinion. We all of us. Judge may grant bail, may not grant bail. We don't know. We don't do that. But if he goes wrong in a system or what you call a procedure, certainly. But we can't blame him for his opinion. It is one soul concepts. You see. Then comes up, friends, latest judgment of Apex Court of High Court of Karnataka and Honorable Supreme Court's number of situations are dealt with in a different angle. One judgment may be against that. You may also say, sir, can we show one judge's judgment to the other judge and say, argue like this under 482? Always, persuasive. By then, they are equally placed judges. They are called as coordinate bench. We call it a coordinate bench, might have. Then judge said, if the discretion exercised by the judge in his wisdom, in his own way, I may not agree because I stand on a different footing, my concept is. But if you are able to show, if you are able to overthrow whole situation and then say, follow it, I would have. But then lies the logic or magic in the hands of a lawyer to argue with the help of a number of judgments or whatever it is, taking into account the several circumstances that are prevailing in the particular case. Can the High Court cross the boundary of 482 if circumstances demand in the case? Nodi. Extraordinary case, any number of judgments have come up. We remember, I don't remember the case, an instance where a young man of 28 years, all wrong side. Then judges took such a view. Judges, you see, I remember thrice, twice, 4 times they adjourned the division bench matters. For that, they said, sir, we are extremely papa, yen madbakri, yenadru one technicality hudiki kodana andre yenu sigtavalvalla anta nodi konege ondu eno hudiki avaru no oh, this is there haudu a competent authority question elli baruttali, who has taken the charge, who has conducted the investigation, who not below the rank of idu nodi avella hudukri ivare anta helkottu papa helkottade. That is why it can cross, provided you are able to show that this is the guidelines there. adu heltaralla every result gu one answer ide, every preparation one uttara ide, every argument one answer. Either judge will defeat or judge will decide. But that's not our concern. What only to argue and show that this is the point involved in 482 petitions. But most of the judges, we know, they will not permit us to argue more because compass is very small. Though the section says it does not limit, but it limits because we are putting an head, what you call as a nip in the bud and avoiding the what you call as further cross-examination evidence and all that, which would come to light in the broad daylight. Therefore, that aspect has to be gone into. Then comes up, can you override the express provisions? Several times we have come across this proposition. The express provisions are there, no doubt. But would they apply to this case is one aspect which the judges should understand again. Though there is a legal bar, can there be an exception? We all of us know there are definitions, there are clauses, the explanations, the exceptions. Yalla broader agi they have gone into. There is nothing remains for us to argue because all things are compassed and they are all put in different clauses and we cover. For example, even rape case now, number of cases were come across 482 hakirtare 376. Complaint says 2 ವರ್ಷಗಳಿಂದ ನನ್ನ ಜೊತೆ ಇದ್ದು ನಮ್ಮನ್ನು ಹಾಳು ಮಾಡಿ. No, nothing. It can't be because there is no huge and cry. Nobody has, she has not gone against him. She has conveniently consented for that. It's a consented affair. Court is no, because the definition says whoever undergoes sexual intercourse with a lady or a woman against her wish, without her consent, by taking her consent, by putting her in a fear of death or injury, nothing is there. Nothing can. Therefore, they say it can't be. Because you see, all said and done is 482 again is the wisdom of the court or the experience of the court or majesty of the court, depending upon the Supreme Court. Kuda yellow one case nalli agale helid case mudadralli they will say 482 admele they will not entertain because no sorry, then don't ask us to again probe into the facts thereafter do it. Then comes at any stage of proceedings. What do you mean by any stage of proceedings? Sometimes even it can be filed twice also. We say we file sir, complaint is not maintainable, learned judge has taken cognizance and come. They say either revision or 482. Then the judges will be asking, what is your case and all that. He says, sir, this is like this, sir, there is no sanction. Learned judge issues summons. No court shall take cognizance is one of the aspects of the matter. Some judges, no, these matters are all covered. Sanction can be taken at any stage, mister. We all of us know. Rest all things I have seen. It's not very easy a case. I will do one thing. I will dismiss it right now, withdraw it, come after charge sheet. These are the experiences. Therefore, at any stage means meaning and effective. Any stage and any stage. Any stage means it is a stage where another stage comes up. But courts have entered that stage. I told an instance where even it has gone to 313 stage. 313 stage. Evidence agoito. Because the court say, no, there is injustice here. Not. Only accused number he was not there. Nothing was said against him again. 2 and 3 will control. Our in defense 313 bantu. 313 there was some problem. The 313 concept we all of us know. I need not emphasize. 1997, 19 there Supreme Court only it was challenged because 313 says we have to answer the question put by the judge. Then the quarrel was to the Supreme Court, sir, why should you tell about me myself, sir, when I am an accused here? It is about persecution to prove. Is it not unconstitutional? Supreme Court, no, Supreme Court, you don't know the concept of 313. Concept is not, in fact, learned judge, trial judge wants to know the reality or truth. He wants to unreveal the truth. He wants to open. Therefore, it may be in your favor. We don't know. Sometimes 313 statements are asked and answered in favor of the accused. In favor of the accused. In one case, Supreme Court young learned judge has acquitted him even at the stage of 313 only because of asking such. See the item situation. Time Supreme Court sack matyak in judgment persteri adanaki to certificate copy come to the court. No, sack that ends. Therefore, 482 has no boundaries, though it has as per the narrowity of the section. Then the long drawn quarrels. Long drawn quarrels and long drawn quarrels. ಅದು ಯಾವುದೋ ಒಂದು ವಿಮಾನದ ಫ್ಯಾಕ್ಟರಿ ಓನರ್ ಅವನು ಯಾವ್ದೋ ಟಿಕೆಟ್ ಇದು ಹಂಗೆ 10 ವರ್ಷಕ್ಕೆ ಹೋಗ್ತಾನೆ ಇರ್ತದೆ ಲ್ಯಾಂಡ್ ಎಕ್ವಿಷನ್ ಅದು ಮಣ್ಣು ಮಸಿ ಈ ತರ ಕ್ರಿಮಿನಲ್ ಚಾರ್ಜ್ ಆಗಿ 10 ವರ್ಷ. Then court will say what is going on all this for the last quarrel. You do one thing, you put an end to all this and the Supreme Court has done. Even for it, High Court has also done. They say long term quarrel idre ಮಾಡಬಹುದು. Equation, for example, common cause ಬರೋದು ನೋಡಿ. Supreme Court said common cause case ಮಾಡಿಬಿಟ್ರು. ಇಷ್ಟು ವರ್ಷದಾಗ ಎಲ್ಲ ನಿಕಾಲೆ 3 ವರ್ಷ ಹೋಯ್ತಪ್ಪ. Then they made exception. Oh, NI Act does not come. ಈ ಆಕ್ಟ್ ಬರುದಿಲ್ಲ, ಪ್ರಿವೆನ್ಷನ್ ಆಫ್ ಕರಪ್ಷನ್ ಬರಲ್ಲ. ಓಕೆ, the prevention of corruption does not because it does not apply at all. ಅದು ಎಷ್ಟು ವರ್ಷ ನಡೆದು ಏನು ತೊಂದರೆ ಡಿಪೆಂಡ್ಸ್ ಆನ್ NI Act ಅಷ್ಟೇ. For others, they say common cause ಹಾಕ್ಬಿಟ್ರಿ 6 years or 5 years finish. Therefore, Supreme Court also always if you have a feeling, Supreme Court also has a feeling ಏನು ಈ 482 ಚೆಕ್ ಮಾಡ್ಕೋತಾನೆ ಬಿಡ್ಲಿ ಏನೋ ಮಾಡ್ಕೋತ ಹೋಗ್ತಾರೆ ಹೈಕೋರ್ಟ್ ಅಂತ ಅವ್ರು ತಿಳ್ಕೊತಾರೆ. ಬಟ್ ಹೈಕೋರ್ಟ್ ಕಾನ್ಸೆಪ್ಟ್ ಅವ್ರು ಏನಾಗ್ತದೆ, lawyers convince them this way, this is the situation, 10 years, 15 years, what can be done? So then you do one thing, like close it. So this is the way in which, but subject to again, injustice, securing ends of justice, that is all the concept that, and it should not be contrary to law also. By questioning this, you should not agree, you don't plead equality in illegality. No, it depends on the case. Then friends comes, meeting single peace and harmony ante adu helidane any number of cases have done and yavado on litigation 65 years husband has filed a petition to divorce against avaru enri what is all this, you are nearer to the second world war after all. We don't want you to be very happy for 100 years, but you have already crossed 65. What is all this you are doing? Then criminal case, sir, when I was not there, she has taken all the golden ornaments, she has run away. On the criminal court court said, what is all this? Is husband wife or then they said, come here, the chambers, let's finish something. Therefore, court, you see, can go a step further to get a single peace, PACE and harmony. Our object of law, after all, object of law, but Supreme Court, any number of cases, Supreme Court has said, object of law is to see that peace shall remain, law shall remain, majesty shall remain, injustice should not occur, secure the interests. They equated it and they quashed it. Badly, we quashed it by with consent here first. But Gyan Singh case Gyan Singh 233 Supreme Court for to make up the harmony. Even 307 they have given you see compromise petition to be allowed, whereas 306 Supreme Court says recently no, nothing. Therefore, it goes on the judges what you call as freedom or what the judges thinking or judges thoughts. Then how about Supreme Court reversing the order of High Court? If High Court order reverse ಮಾಡೋದಕ್ಕೂ ಅವ್ರು ಏನು power, then the Supreme Court the article 32 or ಯಾವ್ದು ನಿಮ್ಮ appeal ಯಾವ್ದು ಹಾಕೊಳ್ಳಿ criminal ಗೊತ್ತಿಲ್ಲ. But the point is, if 482 is exercised by the High Court judge, sitting as a High Court judge under 482, Supreme Court would also have got to open the pages of 482. What else they can do? Then they will say, all our judgments are there before us, we have put them together on the table, you will see. For that also there is no end, because Supreme Court again, Nodi, Bhajan Lala, any number of judgments have come every year. You may check up AR volumes. Every volume contains 4 or 5 judgments. 482, yes, sir, yes, no, yes, no, yes, no. But ultimately, again, what is said then is, even Supreme Court also says, 482, we give guidelines to the High Court and we don't step into 482. Latest Niharika Niharika case 2021 bardu. Niharika dalli contract act adu mannu shala dialogue antavu. They said, no, ನೀವು ಹಂಗೆ ನೀವು ಏನಾದ್ರೂ ಮಾಡಿ 482 ಅಲೋ ಮಾಡ್ಕೊಳ್ಳಕ್ ನಾವು ಕೊಡಂಗಿಲ್ಲ. ಅಲ್ಲಿ you have to make bridges and columns. This, what is the complaint? What is the allegation? Is it according to law? Can it be? ಇದೆಲ್ಲ ನೀವು ತೋರಿಸಿ ನಮಗೆ 482 ಅಲೋ ಮಾಡಬೇಕು ಅಂತ ಹೊರಟ. We conducted recently, just ಬದಾಮಿಕರ್ ಸಾಹೇಬ್ರು ಒಂದು ಮನೆ ಕೊಟ್ಟರು. ಅದು ಸಿವಿಲ್ ನೋಡಿ, ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ, ಸಿವಿಲ್ ಸೂಟ್ ಇದೆ ಹೇಳೋದಿಲ್ಲ. Then we filed 482 to produce all that in civil suit pending. ಅದರ ಮೇಲೆ ಇದೆ ಸೇಲ್ಡಿಡ್ ತಿದ್ದುಪಡಿ ಮಾಡಿದ್ದಾರೆ ಅಂತ yes filed. High Court said, no, this is too much, you see. He has not only gone to civil court, he has suppressed also. Then Sukeswar state and the report made. They said, you see, even in that case, Niharika case was referred. Niharika case cautioned, don't do this on Supreme Court. But his lordship said, in this case, there is a chance, there is a most chance, there is a guarantee that he is giving a criminal color to a civil case, which was not what he is not able to do in civil court, he wants to do in criminal court, harassing. Relatives will not question. No, that is enough, because civil decrees are there, you got to take up remedies and all. Therefore, it goes on the how the experience of a judge, mobility and mobility modify. Even Supreme Court in some cases reverse modify no ಮಾಡ್ತಾರೆ. Now, so far as accused 3 and 4 concerned, we don't but 1 and 2 will send it back and go do whatever. That also may be. It goes on the complexity of case. Then, if the 1994 Supreme Court ali a judgment came up, 3-judge judgment, they said, in a criminal case, how best, what is the edge or what is the gates of 482? The lordship said, the lordships expressed, if the judge is certain that, if the judge feels he is certain that it will end in acquittal, he may drop it. No, he should. Forgetting all acts, law, this, that, limitation, everything. Very interesting. He says, if the judge is certain while reading the file that it will end in acquittal, give him, because only 10 years, what are going to do? Therefore, again, that's why there is a tail end, has no end at all. It goes on. It goes on the complexity, development of law, this and that, latest laws, even American laws, foreign laws are referred to in number of England report, because the experience of a judge. Then comes of moral turpitude. You know that the judges are normal. Then 482 which was limitation time bar complaints. In a time bar complaint, there is again a rectangle U-shaped formula. Some judges say limit. We all of us, it is a natural experience. Limitation is a question of law and facts. We don't entertain it. Let the party does whatever it does, let in trial court come thereafter. But in criminal law, if a statutory limitation is provided under 468 or 473, court will not, the expression used is, no court shall take cognizance for the offences in respect of which more than 3 years, when the limitation itself for filing complaint is the time barred, would not take it. So this complexity arises, and whatever is there, it depends. Therefore, time barred complaints andre time bare, statutory period bare, latches bare. Pepsi court alla Pepsi university allo ಬರ್ದಿದ್ದಾರೆ. ಯಾವಾಗ ಬೇಕೋ 10 years ಅಲ್ಲಿ ಬರುತ್ತೆ. there comes what I call as ಅದು delay ಅಲ್ಲ, ಅದಕ್ಕೆ latches ಅಂತ, latches. But Supreme Court has entertained, because on the face of it, if it is illegal, why to hesitate? Because how the party should for a long time, 10 years, 15 years, dozen of years. Therefore, the complexity is, if it is legal bar under limitation, it will not. And especially when there is no provision to apply for condemnation also. ಈಗ ಸೀಡ್ಸ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ನಂಬರ್ ಆಫ್ ಪ್ರಪೋಸಿಷನ್ಸ್ ನಾವು ಮಾರ್ಕ್ಸ್ ರಿಪೋರ್ಟ್ ಆಗುದು ಲೈಕ್ ಇಟ್ ಹ್ಯಾವ್ ದಟ್. ಅಲ್ಲಿ ನೋಡಿ ಜಸ್ಟ್ ಪುನರ್ ಸಾಹೇಬ್ ಎಷ್ಟು ಬರೆದ್ರು. ಕಂಪ್ಲೇಂಟ್, ಈಗ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತಾರೆ, ಅದನ್ನ ಕಳಿಸ್ತಾರೆ. ದಟ್ ಸೀಡ್ಸ್ ವಿಲ್ ಬಿ ಸೆಂಟ್ ಟು ದಿ ಟೆಸ್ಟ್ ವಾಟ್ ಎವರ್ ಲ್ಯಾಬೊರೇಟರಿ. FSL report comes, and within 1 year from that date, complaint has to be lodged. ಅಥವಾ within 6 months, because limitation punishment is 6 months. ಶೈಲಜಾ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಅಂತ ಬರೆದ್ರು, ವಿ ಚಂದ್ರು ಅಂತ ಬರೆದ್ರು, ಜೈನಾರಾಯಣ ಅಂತ ಬರೆದ್ರು, ಏನ್ ಬರೆದ್ರು ಎಲ್ಲ ಇವು ನೋಡಿ. and beyond a period of 1 year complaint they file without application of even condemnation if it is permitted. That also is not done. Then in some cases they file the complaint immediately, but the accused, it reaches the accused hands after 3 years. Right to retest has gone therefore question. Just types, any number of types of. And in another case, fortunately, one set is sent to a laboratory. Laboratory says no problem. Unfortunately, he sends within 15, another one, he says it is there. Learned judge says, no, benefit of doubt. So Lalappa's case, right from any number of judgments you have seen, if two views are possible in a case, the view favorable to the accused must be followed, the accused must be benefited by that is the answer. Banur Motaiah reported 10 of judgment, JNR, any number of concepts. Because statutory offenses, therefore 482 and 482 hackbitrary and Mugitendri Handal 482 hackbitrary Akaktare. There is sense in it, you see. Instead of going for a trial for years together, enjoying the court by joining head as accused, he wants to file it, and if the court finds it has to. Therefore, most of the technical cases are thrown not on the merits of case or authorities. Next comes up, friends, what is called as regarding cognizance order. Cognizance of cognizance concept of hundreds of judgments, right from D.P. Sharma, Mallikarjuna Prasanna, any number of judges. Learned judge says, I so and so, I see the material, cognizance is taken, issue process. We challenge it on the ground, there is no application of mind at all. Modi's case, this D.P. Sharma's case. Then the question is whether judge should take cognizance first, issue process, or summons later, or issue summons first and then the cognizance. There is all the various. If the learned judge takes sworn statement first and issues process, issues cognizance. Mallikarjuna Prasanna is our own High Court, as back as 1998 said, no, following D.P. Sharma division bench, their lordship said, first you must take cognizance. If you want to take, if you want to have cognizance, have first, then get it in the witness box and examine it. Then the other judge said, no, it is then the lordship says, no, by putting him in the box itself, so there is a cognizance. Then latest judgment of the lordship justice Harish Sahib says, Harish says, Harish Sahib's judgment says, sorry, extremely sorry, sir. Don't mistake me, sir. Srinas Harish Sahib says, no. There is yet another angle you have to see. Even putting him in the box earlier will not invalidate the order because it is irrespective of the person. Therefore, friends, we are lawyers as he wants. We do not know where to wish and where to swim in the law. We don't know. But with all this glamour, lawyers fight for accused to get or not with the different issue. Not even now that again Supreme Court now has to answer this query because another Allahabad High Court judge has written a beautiful judgment of 17 pages again reiterating the situation. He said, shall I refer it to? But the D.P. Sharma is the division bench. D.P. Sharma is division bench. We're bound to accept. Mallikarjuna is single judge. The lordship say the word used is a magistrate taking cognizance of an offence. First he must take one if he wants to. Don't take Allah. Shall examine on this. But the Honorable High Court presently says, no, that is not technical aspect. That is not the point at all that you want to reach. So therefore, but this sandarbhadalli 482 nalli, if this ticklish point is involved, judges may say, all right, right now we will grant an interim order, we'll see what happens later. That's all. But adu cognizance order, for example, I'll give cognizance, learned judge does not see to it that complaint is not filed by competent person. One the other child either on the act and we conducted a case later, very recently. That case belongs to what we call as 1 minute. There is a very recently conducted case. It was before 482 that the Juvenile Justice into bracket Care and Protection of Children Rules 2000 Act anta bantu. Ali a complaint is lodged by an NGO lady officer before the police saying that sir in nursing home ali so and so doctor so and so antiddare iವರು ibru nurse ibru doctors 3 ಮಂದಿ nurse ಸೇರಿ ಈ ಮಗುನ they want to ಸೆಲ್ ಅಂತ ಏನೋ ಒಂದು ಕಂಪ್ಲೀಟ್ ಕೊಟ್ಬಿಟ್ರು. FIR ಮಾಡುವಾಗ ಅಡಾಪ್ಟ್ ಮಾಡ್ಕೋತಾರೆ ತಗೊಂಡಿದ್ದಾರೆ ನೋಡಿ. ಇಟ್ ಕೇಮ್ ಅಪ್ ಬಿಫೋರ್ ಸಮ್ ಜಡ್ಜ್ ದೇ ಸೆಡ್ ಡ್ಯೂರಿಂಗ್ ಇದರ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಕೋವಿಡ್ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಬಂತು. then I said, sir, this doctor has saved hundreds of lives. If you want to arrest him, nothing can work. Oh, that is a different issue. Please tell me the case. Then I told him, sir, this is situation. Complaint is, and above all, there is a note that child has already reached the mother. What type of? Then there was some grant entry, or thereafter it came up for another learned judge. What is all this? 4%. There is a height of ಸ್ವಲ್ಪ ಏನು ಇಲ್ಲದೇನೆ ಈ ತರ ನೀವು ಲಾ ಸಿಸ್ಟಮ್ ಮಾಡಿದ್ರಿ. ವಾಟ್ ಈಸ್ ಇನ್ ದ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಸೇಲ್ ಮಾಡಂತಾರ, ಅಲ್ಲಿ ಅಡಾಪ್ಟ್ ಮಾಡ್ಕೊಂಡಂತಾರ, ಅದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ, ಮಗು ಅವ್ರ ಕೈಲಿ. ವಾಟ್ ಈಸ್ ಆಲ್ he said is the best case for you see exercising power under 482 because it is abuse of process of those two doctors who have saved the lives of is argued like this. ಅವ್ರು ಎಲ್ಲ ಯಾಕ್ರಿ why do you bring them to court? Question. Therefore it is ಅದು ಅದಕ್ಕೆ ನಾವು ಏನ್ ಹೇಳ್ತೀವಿ ಅಂದ್ರೆ ಅದು ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಅನ್ನೋದು ಬಿಟ್ಟರೆ ಮತ್ತೇನು ಅದ್ರಲ್ಲಿ ಇಲ್ಲ, ಎನಿ ನಂಬರ್ ಸಿಚುವೇಶನ್ ಇಲ್ಲ. ಅದಕ್ಕೆ ಹೇಳ್ತಾರ 2007 ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನವ್ರು ಹೇಳಿದ್ರು ಏನಂದ್ರೆ ದಟ್ ಈಸ್ ಹಲ್ಲಬಾನ್ ಕೇಸ್ ಅಂತ. ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದಾರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಸೇಸ್ ಇಫ್ ಯು ಈಗ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇಫ್ ಯು ಆಸ್ಕ್ ಎ ಪರ್ಸನ್ ಟು ಕಮ್ ಟು ದ ಕೋರ್ಟ್ ಬೇರೆ, ಕಮ್ ಅಂಡ್ ಅಪಿಯರ್ ಮರ್ಯಾದಿ. ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಅಲ್ಲಿ ಇಫ್ ಯು ಇಶ್ಯೂ ಸಮನ್ಸ್ ಟು ಹಿಮ್, it is as good as degrading him and bringing down his image in the society. Therefore they say we also take care that direct summons issue ಆದ್ರೆ ನಾವು ಸ್ವಲ್ಪ ನೋಡ್ತೇವ್ರಿ, ಹಂಗ ಇದನ್ನ ಮಾಡೋದಿಲ್ಲ, ಸಿ ಆಲ್ ದಟ್ ಅಂತಾರೆ. ಯಾಕಂದ್ರೆ ಏನು ಇಲ್ದೇನೆ ಸುಮ್ಮನೆ ಹಂಗೆ ಕಬ್ಬಡ್ಕೊ ಇಶ್ಯೂ ಸಮನ್ಸ್ ಅಂದ್ಬಿಟ್ರೆ ಮೆಕ್ಯಾನಿಕಲಿ ಅಲ್ಲ. ಅದು ಇಶ್ಯೂ ಸಮನ್ಸ್ ಟಾಪಿಕ್ ಬಗ್ಗೆ ಎಷ್ಟು ಜಜ್ಮೆಂಟ್ಸ್ ಇದೆ. Some judgments say judge need not go into details, let him pass orders. The other judge, no, he must go into elementary. It is he should not only say I have read the file, it should be reflected in the file. Yeah, reflect, open ಮಾಡ್ತೀವಿ ನಾವು ಕ್ಲಾಸ್ ಹಾಕಿ, goes again. ಅದು ನೋಡಿ, then what happens is then after the judge will go again to the complainant to know what is being done. Therefore friends, but with all this now ಇನ್ನೊಂದು ಪ್ರಶ್ನೆ we ask ourselves, can this exercise, how long this will go on, can this exercise be helpful? We can't say. You see, our endeavor is only to see that it fits into the formula of what you call as bhajan lal or whatever it is. Thereafter we can't help, and they just say they're feeling with that. Then comes a friends regarding investigation by the police. Most of the judges are of the view nowadays, they say don't stall the investigations because truth will not be revealed, you will get the benefit for 5 years. So adu olagadisthira adu barudilla amele question. No, there are cases wherein investigation has to be stalled. There are cases wherein it cannot be stalled. It depends upon what happens. Several judges issue notice and thereafter comes the final ಮಾಡ್ಬಿಡ್ತಾರೆ. But it's not possible. It depends on the circumstances. By then the party may suffer. We don't know. Investigation are ಏನಾಗ್ಬಿಡುತ್ತೆ, police they have got their own ways of doing things. ಅವ್ರು ಬೇಕಾದ್ರೆ 2 ದಿವಸದಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ತಾರೆ, ಇಲ್ಲ 6 ತಿಂಗಳು 9 ತಿಂಗಳು ಹಾಕೋದಿಲ್ಲ. ಅದು ಪೀರಿಯಡ್ ಹಾಕಿದ್ಮೇಲೆ ಬೇಲಕ್ಕೆ ಎಲ್ಲ ಮಾಡಬೇಕು. Of course we can't come and to see it is a system maintained and things are going like this. We can't blame either I am blaming, he is blaming. No. System is going. But we have got to adapt with this. But what best can be done is only under 482 answer for the. Then can a 482 be dismissed earlier and come again? I told you several times. Complaint ಅಲ್ಲಿ at the complaint stage, cognizant stage ಅಲ್ಲಿ ಹೇಳ್ತೀವಿ ಸರ್ ಅದು jurisdictional magistrate ಅಲ್ಲ, word use jurisdictional magistrate ಅಂತಿದೆ. He is not under the notification, he is not the magistrate to exercise under the very cool act not therefore ಅಂತೀವಿ. ಹಂಗ ಅಡ್ಮಿಟ್ಸ್ಟೇ ಅಂತ ಬಂದು ನೋಡ್ತೀವಿ. ಅವಾಗ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಅಲ್ಲಿ ಸಪೋಸ್ ಅದು ನಾಳೆ ಅದು ಇತ್ತು ಅಂತ ಬಂತು ಅಂತ ಆದ್ರೆ ಏನ್ ಮಾಡ್ತಾರೆ, ಸಪೋಸ್ ಇದೆ ಅಂತ ಆದ್ರೆ ಓಕೆ ವಿಲ್ ಡೂ ಅಂತ, then we'll ask him to do it within a period of 1 month from today, 2 months, 3 months, 5 months, 6 months, very good. Partially also the intent. Sometimes ಎಷ್ಟೋ judges we know, several judges have not granted interim order, they have given another beautiful order, do it within a period of 1 year. ಸಾಕು, ಬ್ಯಾಸ್ಟ್ ಆಗೋದು ಡಿಪೆಂಡ್ಸ್ ಅಗೇನ್ ಹೇಳ್ತಾರೆ. ಮತ್ತೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಗೇನ್ ಸೆಡ್ ಡೋಂಟ್ ಪ್ಲೇಸ್ ಪಾಪ ಅವರು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮೇಲೆ ಹಂಗೆ ಮಾಡಬೇಡ್ರಿ. ಮತ್ತೆ ಏನ್ ಮಾಡಕ, ವಾಟ್ ಬೆಸ್ಟ್, ನಮ್ಗೆ ಅಲ್ಲೂ ಇಷ್ಟೇನು ಇಲ್ಲ, ಇನ್ನೂ ಇಲ್ಲ, ಒಳ್ಳೆ ಕೇಸ್ ಆಗುದಿಲ್ಲ, ವಾಟ್ ಕೆನ್ ಬಿ ಡನ್ ಅಂತ ಹೊತ್ತಿನಲ್ಲಿ 482 can be operated. They will say we'll do one thing sir, give an undertaking. They ask prosecutor you tell your counterpart ಮುಗಿಸ್ಬೇಕಾದ್ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ಏನ್ ಮಾಡ್ತಿರೋ ಮಾಡಿ. This is all the, that's why common cause case ಬಂತಲ್ಲ. ಮತ್ತೆ 10 ವರ್ಷ ಹಂಗೆ ಇಟ್ಕೊಂಡ್ಬಿಟ್ರೆ ಇಕನಾಮಿಕ್ ಅಫೆನ್ಸಸ್ಗೂ ಮತ್ತು ಪ್ರಿವೆನ್ಷನ್ ಆಫ್ ಕರಪ್ಷನ್ ನೆಗೋಸಿಯೇಷನ್ ಬಿಟ್ರೆ ಉಳಿದೆಲ್ಲರೂ ಕವರ್ ಮಾಡಿದ್ರಲ್ಲ. ಮತ್ತೆ ಎಷ್ಟು ಕೇಸ್ ಹೋದ್ರಲ್ಲ, thousands of cases thrown because they are not able to find ಕೇಸ್ ಹಾಕ್ತಾರೆ ಅನ್ನೋ ಅದು ಮಾಡೋದಿಲ್ಲ. ವಾಟ್ ಎ ಲಾಯರ್ ಕ್ಯಾನ್ ಡು ಅಂತ ಹೊತ್ತಲ್ಲ obviously 482 comes in. ಎಷ್ಟು 482 experience ಬೇಕು ಸರ್, ಎನಿ ನಂಬರ್ ಎನಿ. ಬಟ್ now again I am telling you it is judges experience, judges faith, judges thinking, judges what you call as his view over that, his vision over the subject, that only prevails. Then comes subsequent event. For example, notice ಅಂತಾರೆ, ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿರ್ತಾರೆ, subsequent event ನಾನು ಏನು ಮಾಡಲಿಕ್ಕೆ, then they will say withdraw it. Some judges allow us to amend. ಒಂದು ಅಮೆಂಡ್ಮೆಂಟ್ ಕೊಟ್ರೆ, ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿಕೊಟ್ರೆ you can challenge that. charge sheet. Some judges say, no, we don't do that. We'll very happy permission ಕೊಡ್ತೀನಿ ನಿಮ್ದೇನು ಹೊತ್ತು ಅಂತ. That is his feeling. He is a judge after all. In every judge, you see his ಅದೇನೋ ಹೇಳಿದ್ರು London period, every judge has got right to pass a wrong order. ಅಂದ್ರೆ humorous sense ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. Humorous sense ಅಲ್ಲಿ, in a good humor, they say every judge has got right to pass a wrong order also. Don't forget, but it is a judge. He provided he feels it right. ಎಷ್ಟು ಚೆನ್ನಾಗಿ ಹೇಳಿದ್ದಾರೆ. English speakers, they say every judge has right to pass a wrong order, provided he feels it right. Because there is no judge. ಯಾರೋ ಒಬ್ರು ನಮ್ಮ MN ವೆಂಕಟೇಶ್ ಒಂದು ಸ್ಪೀಚ್ ಅಲ್ಲಿ ಹೇಳಿದ್ರು ಹಿಂದೆ, there is no judge. There is no judge who would say, I have judgments, all our judgments, no judgment is set aside. No lawyer will say, I will succeed. No. Therefore, 482 ವೆಜ್ ಬಂದಾಗ every case ಒಂದು ಅದು ಸ್ಟೋರಿನೇ ಬೇರೆ ಹೇಳ್ತದೆ ನಾನು. Every case is different. Judge has to visualize situation and do. Then comes a friends, suo motu power idea. There is in one, I think 1998 or 99 Supreme Court ಒಂದು ಕೇಸ್ ಬಂದಿತ್ತು. Supreme Court suo motu power ಯಾಕಂತಾರೆ ಅಂದ್ರೆ ಅವರು suo motu 482 ಪಿಟಿಷನ್ ಇದ್ದಂತೆ ಇಟ್ಕೊಳ್ಳೋದು ಇರ್ಲಿಕ್ಕೂ ಇಲ್ಲ. Court can say, no, they can do it. Even in ordinary petition, they may accept, because inherent power, it's not as if you must ask and give one power pit ಮಾಡಿ ಬಿಟ್ರಲ್ಲಿ. Inherent power is there with. Therefore, our endeavor is subsequent. Even I am telling you, even that suo motu power also can be used by the High Court. Is one of the expressions of 99 Supreme Court ಅಲ್ಲಿ ಕೇಳಿದ್ರು ಮಾಡಬಹುದು ಅಂತ they say. ಆಮೇಲೆ ಸ್ಯಾಂಕ್ಷನ್ ಕ್ವಶನ್ ಕಮ್ಸ್. ಎನಿ ನಂಬರ್ ಆಫ್ ಇವ್ರು ಹೇಳಿದ್ರು ಈಗ ಸ್ಯಾಂಕ್ಷನ್ ಇಸ್ ವೆರಿ ವೆರಿ ವ್ಯಾಲಿಡ್ ಗ್ರೌಂಡ್ ಟು ಪಾಸ್ ದಿ ಆರ್ಡರ್ಸ್ ಅಂಡರ್ 480. ಅದರಲ್ಲೂ ಜಡ್ಜಸ್ ಆರ್ ಡಿವೈಡೆಡ್ ಅಗೇನ್. ಪ್ರಿವೆನ್ಷನ್ ಆಫ್ ಕರಪ್ಷನ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಸೆಷನ್ಸ್ ಸ್ಯಾಂಕ್ಷನ್ ಇಸ್ ನೆಸರಿ ಅಂತ. ಅಲ್ಲಿ ಸೆಕ್ಷನ್ 19 ಆಫ್ ನಿಮ್ಮ ಇದರಲ್ಲಿ ಪ್ರಿವೆನ್ಷನ್ ಆಫ್ ಕರಪ್ಷನ್ ಆಕ್ಟ್ ಹೇಳಿದೆ. 197 ಆಫ್ IPC ನಲ್ಲಿ CRPC ನಲ್ಲಿ ಹೇಳಿದೆ, ನೋ ಕೋರ್ಟ್ ಶಾಲ್ ಟೇಕ್ ಕಾಗ್ನಿಸನ್ಸ್ ಅನ್ಲೆಸ್ ದರ್ ಇಸ್ ಎ ಸ್ಯಾಂಕ್ಷನ್ ಆಬ್ಟೈನ್ಡ್ ಇನ್ ಅಕಾರ್ಡೆನ್ಸ್ ವಿತ್ ಲಾ ಅಂತದಲ್ಲಿ. ಅಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ, ಇಫ್ ಸ್ಯಾಂಕ್ಷನ್ ಆರ್ಡರ್ ಪಾಸ್ ದೇ ವಿಲ್ ಚಾಲೆಂಜ್. Sir, sanction ilde idre, that is one aspect. Again, court will say, no, looking to the circumstances of the case, in this case, keeping apart all the laws, all the judgment, sanction necessary here. Look at technical aspect. Some judges will say, no, sanction that can be taken later also, sir. What is going to happen? Some judges say, there are judgments here. Innondralli, sanction is granted, but there is no application of mind, because our evidence alli, sanction, when the sanction order is placed on my table, 7 draft copies were there. I have read that and then passed it. What is all this? 7 orders are passed according to pass in adhe tara in format agudadu. No, court say, no, you are not applied with sanctions. Therefore, elladukku ಒಂದು ಆಮೇಲೆ a sanction is granted by a person who is incompetent to grant sanction. Again question. Therefore, ಈ ಯಾವ್ದರ ಒಂದು ಹೆಜ್ಜೆ ಹಿಡಿತದ, ಆ ಹೆಜ್ಜೆಯಲ್ಲಿದ್ರೆ 482 ಅಷ್ಟೇ ಬಿಟ್ರೆ ಉಳಿದ 482 ನೋ ಯೂಸ್, ಫೈಲ್ ಇಟ್ ಅಂಡ್ ಡ್ರಾಪ್ ಇಟ್ ಅಷ್ಟೇ ಇರ್ಬೋದು. ದೆನ್ ಕಾಂಪ್ರಮೈಸ್ ವಿಷಯದಲ್ಲಿ ಐ ಆಮ್ ಅಗೇನ್ ಟೆಲಿಂಗ್ ಯು, ನೋಡಿ ಗ್ಯಾನ್ ಕೇಸಲ್ಲಿ 307 ಮಾಡಿ ಹಾಕಿದ್ರು ಅವರು. 307 ಬರುವುದಿಲ್ಲ ಅನ್ನೋ ನಾನ್ ಕಂಪೌಂಡೇಬಲ್, ಬಟ್ ಇನ್ ದ ಇಂಟ್ರೆಸ್ಟ್ ಆಫ್ ಅಂತ ಬರ್ಕೊಟ್ಟು ಕೋರ್ಟ್ಸ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಸೆಟಲ್. ಬಟ್ ಅವ್ರೇನಂತಾರೆ 142 ಬೇರೆ ರೀ, 482 ಬೇರೆ. ನಾವು 142 ಆಫ್ ದಿ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್, ಇಟ್ ಈಸ್ ದ ಪವರ್ ಆಫ್ ದ ಹೈಯೆಸ್ಟ್ ಕೋರ್ಟ್ ಆಫ್ ಇಂಡಿಯಾ, ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್. ಲಾ ಡಿಕ್ಲೇರ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಸ್ ಬೈಂಡಿಂಗ್ ಆನ್ ಆಲ್ ದ ಕೋರ್ಟ್ಸ್, ಟ್ರೈಬ್ಯುನಲ್ಸ್ ಎಲ್ಲ ಇದೆ. Even High Court, Trial Court, even to the parties also, you can't disobey. But High Court power 482, we can't do what the Supreme Court does. We have only got to obey it, follow it, use our discretion in good manner, do it. That's all. Then comes up compoundable and non-compoundable offense ಬಂದಾಗ ಸ್ವಲ್ಪ ಅಲ್ಲಿ ಥ್ರಿಲ್ ಬರುತ್ತೆ. ಸ್ವಲ್ಪನೇ ಒಂದು ನಾನ್ ಕಂಪೌಂಡಬಲ್ ಅಫೆನ್ಸ್ ಕೂಡ ಮಾಡಿಕೊಟ್ಟಿದ್ದಾರೆ in the interest of parties ಅಂತಿದೆ. It's not as if it's not possible at all. Circumstances giving rise to that. Then parallel civil dispute ಅಂತ ಬರುತ್ತೆ. We know any number of judgments. ಅದು ರಾಮ್ ಕುಮಾರ್ ಪೌರಿಸ್ ಕೇಸ್ ಅಂತ 1985 472 ಅವಾಗ ಬರೆದ್ರು. 1985 ಸುಪ್ರೀಂ ಕೋರ್ಟ್ 472 ರಾಮ್ ಸುಮರ್ ಪುರಿ ಕೇಸ್. ಆಲ್ ಆಫ್ ಅಸ್ ಯುವರ್ ಯಂಗ್ ಲಾಯರ್ಸ್. ದೆನ್ ಅವಾಗ ಏನಂದ್ರು, ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇದ್ರೆ ಮಾಡ್ಬೇಡ್ರಿ, ಇವನ್ 145 ಪ್ರೊಸೀಡಿಂಗ್ ಕೂಡ ಮಾಡಕ್ ಹೋಗ್ಬೇಡ್ರಿ. ಯಾಕಂದ್ರೆ 145 ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಂಡರ್ CRP ಇಟ್ ಸೆಲ್ಫ್ ಪರ್ಸೆಂಟ್ ಇಮೋಲ್ ಪ್ರಾಪರ್ಟಿ ಮೇ ಬಿ, ಬಟ್ ಇಫ್ ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ಸ್ ಆರ್ ದೇರ್, ಸಿವಿಲ್ ಡಿಕ್ರೀಸ್ ಆರ್ ದೇರ್, ಡೋಂಟ್ ಡೂ. ಅದನ್ನ ಇಲ್ಲಿನೂ ಬರ್ತದೆ, ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಪ್ಯಾರಲಲ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ, ರೈಟ್ಸ್ ಹ್ಯಾವ್ ಟು ವರ್ಕ್ ಔಟ್. Then comes up friends 466 2014 ನಲ್ಲಿ ಮೊಹಮ್ಮದ್ ಅರೀಫ್ ಅಂತ, there is a decided case not reported but not yet reported. ಅಲ್ಲೇ ಜಸ್ಟಿಸ್ ನಾಗಪ್ರಸನ್ನ ಸರ್ ಕನ್ಸಿಡರೇಷನ್ ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಎಷ್ಟರ ಮಟ್ಟಿಗೆ ಅಂತ ಬರ್ತಾರೆ. ಸೇಲ್ ಡೀಡ್ಸ್ ಅಲ್ಲಿ ಅಕ್ಯೂಸ್ ಪರ್ಸನ್ಸ್ ಹ್ಯಾವ್ ಪರ್ಚೇಸ್ಡ್ ದ ಪ್ರಾಪರ್ಟಿ ಆನ್ ಕನ್ಸಿಡರೇಷನ್, by paying consideration. They also issued paper publication that we want to purchase, and if any objections come. After 1 month they have purchased, they have made as accused. Then the lordship said, no. Not only that, there is civil dispute is also there, plus they have issued notice, plus consideration is there. In fact, these accused must have become complainants. I am sorry, they have become accused. Question. Any number of judgments have been followed. Although Sukesh case, Sukalva, number of CC. Then NDPS case. NDPS case, what is heinous conceptually, arms act, militaries often, they are also judges, mind attracts. Naturally, I am telling you, judge is human being first. NDPS argument all lawyers, we all see lawyers, NDPS, sir, weight, weight 11 grams, 5 grams. Okay, very good. Next. Sir, it does not come under the definition of that plant material collected. The NDPS idರಲ್ಲಿ sir. Oh, howda, show me. Sir, the one who has recorded the state, he is not the complaint, can't be lodged with any person. Oh, and the stated to have been done in 2019, complaint in 21. Oh, I see. Not now, you see, as a lawyer, it's 482, but 482. But you technical bandag, judge also can't help. Visualize, we see with the naked eyes, but what can be done? Law is there. Law is jealous mistress and theory. We are bound to follow the law. Unless, I mean, so long as it falls in the category of judgments or whatever it is in situations. So, antavella case the courts commercial quantity, commercial quantity, minimum quantity, the whole tree has been taken. In fact, he should make it a bit and then make it to I see, antare. The bail goes conviction because technical aspect they are one. One answer is what a sane or what an intelligent or whatever good lawyer would say if things are put in this fashion. Can you, if an accused is left alive, you left free because of technicality, what the society would. Because law is that the accused is said to be innocent unless proved otherwise. And all burden of proof largely lies in the prosecution. Prosecution should prove the case beyond all the reasonable doubt. But Kalandra negative or reverse, you have got to prove innocence. France only, you see, you are caught red-handed driving. You have got to explain that you are right. Whereas in India, you have got to explain that the prosecution has to say that you are. What is the change of law? Fantasy. Then comes up interim stay ಬಗ್ಗೆ 482 ಏನು ಅಂತ ಅದೊಂದು ಹೇಳ್ತಾರೆ. ಎಷ್ಟೋ ಮ್ಯಾಟರ್ interim stay ಕೊಡ್ತಾರೆ. Sometimes we with good humor you say, if lordships are granting interim order, lordships are allowing the petition as it is. If lordships are dismissed, no interim order, then no prayer law, so we will withdraw the petition. Because the experience proceedings will go on. But if it really tricking case, really technical aspect, really to enter the gates of High Court, interim order, Supreme Court has no, but there is no meaning in what is all this. Okay, there. A report recently, I think somewhere November 22 report not granting an interim order in a criminal case where it is a fit case. No, we do entertain because nothing otherwise no purpose will be served, sir. Your case will not reach for another 5 years. What will happen? It will not see the light of day. We know. Then comes up, friends, technical offenses. Here the Seeds Act, technical offense, Companies Act. The Companies Act, nim intention sambandilla. Director was not sitting, director was sitting with fault. I vote only. Then Electricity Act, electricity theft, na intentionally nim intention already. Electricity pass or with Kels the Excise Act. Whoever is found in the possession of bottle and the flight naga. Na beg namma yara hudu ittanre. Hudugella padigilla ali chikodu kelas no intention, nobody bothers. Technical aspect of the matter. Nobody, there is no N Act alli en matte. N Act alli there is no alla solpa N Act alli enagutte adruddu smell ide. N Act alli whether it is deliberately check is given or stolen avella solpa smell ide. But bere Act alli enu illa. Forest Act allu illa. Forest sikbitre namagu beku yalla Forest Act products tagondu hodre. We have seen several recently in the papers also. Yavado on the animals, forest animals, they are avella bekanta madam tirudillalla. About the question finished. That's any number of cases, defamation case, for example, result if his name is defamed, if his reputation comes down, his image is trollen or is tarnished, that is enough. We don't know whether you said decent, who bothers. SC/ST Act, for example, no technical aspect. SC/ST Act ಅಲ್ಲಿ ಇಂಥ ಜಾತಿಯವ್ರು ನೀವು ಅಂತ ಬೈದ ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಇರುತ್ತೆ, ಹೆಸರು ತಗೊಂಡಿರ್ತಾರೆ. ಅವ್ರು ಎಲ್ಲಿ ಮನೆಯಾಗ ಬೈದಿರ್ತಾರೆ, ಬಾಗ್ಲಾಕು ಸಾರಿ ಸರ್ ಪಬ್ಲಿಕ್ ಯೂಸ್ ರೀ 310 ಬರುತ್ತೆ ಬರಲ್ಲ ಹೋಗ. ನೋ ಟೆಕ್ನಿಕಲ್ ಆಸ್ಪೆಕ್ಟ್ಸ್. ಆಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಶಾಲ್ ಬಿ ಫೈಲ್ಡ್ ನಾಟ್ ಬಿಲೋ ದ ರ್ಯಾಂಕ್ ಆಫ್ SP ಹೋಯ್ತಲ್ಲ. ಅದಕ್ಕೆ ಏನಾಗ್ತದೆ, ಲಾ ಡ್ರಾಫ್ಟಿಂಗ್ ವಿ ಕಾಂಟ್ ಕಂಪ್ಲೇನ್ ಅಮೌಂಟ್ ಲಾ, ವಿ ಕ್ಯಾನ್ ಓನ್ಲಿ ಟು ಫೈಂಡ್ ಔಟ್ ಇನ್ ವಿಚ್ ಕಾಲಮ್ ಇಟ್ ಫಾಲ್ಸ್ ಅಷ್ಟೇ. ನಾವು ತಲೆ ಕೆಡಿಸ್ ಅನ್ಲೆಸ್ ರೂಲ್ ಇಟ್ ಸೆಲ್ಫ್ ಇಸ್ ಚಾಲೆಂಜಿಂಗ್ validity of the act, validity of the rule, validity of preamble, validity of the order. Otherwise, no. Then comes, friends, prospective and retrospective ಕಥೆ ಏನು ಅಂತ ಬರುತ್ತೆ. 1988 ಅಲ್ಲಿ ಪ್ರಿವೆನ್ಷನ್ ಆಫ್ ಕರಪ್ಷನ್ ಆಕ್ಟ್ ಅಮೆಂಡ್ ಮಾಡಿದ್ರು. ಬಹಳ ಪ್ರಪೋಸನ್, ಅವಾಗೆಲ್ಲ ಸೆವರಲ್ ಜಡ್ಜಸ್ ರೆಕಮೆಂಡೇಶನ್ಸ್ ತಗೊಂಡು ರೆಕಮೆಂಡೇಶನ್ ಆಫ್ ಕಮಿಷನ್ ಇದನ್ನ ಮಾಡಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಪ್ರಾವಿಷನ್ ಹೋಗಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಪ್ಯಾನಲ್ ಕೂತ್ ಅವ್ರು ಏನ್ ಮಾಡಿದ್ರು ನೋಡ್ರಿ, ಇದು ಪ್ರಿವೆನ್ಷನ್ ಆಫ್ ಕರಪ್ಷನ್ ಆಕ್ಟ್ ಏನಾಗ್ತಾ ಇದ್ದಾರೆ, ಸುಮ್ಮನೆ ಬಿಡಾಕತ್ತಾರೆ ಎಲ್ಲಾರು. If a man is found to be convicted, ಅಂದ್ರೆ if he is convicted, minimum 1 year ಮಾಡಿಬಿಡಿ, make 1 year. 1988 amendment. ಅಂದ್ರೆ if you are convicted, ಏನೋ ರೈಸಿಂಗ್ ಆಫ್ ದಿ ಕೋರ್ಟ್ ಫೈನ್ ಕಟ್ಟು ಇಲ್ಲ, 1 year ಒಳಗೆ ಹೋಗ್ಬೇಕು ಮಿನಿಮಮ್. That is the discussion. In one case it so happened, we argued very vehemently and all that. One postmaster, there was some problem, rightly or wrongly, ಏನೋ ಸ್ವಲ್ಪ ಅಮೌಂಟ್ ಇದಾಗ್ಬಿಟ್ಟಿತ್ತು. 5 accounts ಅಲ್ಲಿ ಅಮೌಂಟ್ have a small amount, 200, 300, 500, whatever it is, small or big, we are not to see. Matter was argued this and that, we lost. ಹೋಗಿತ್ತು, ಇಲ್ಲಿ ಬಂತು 3 years, ಇಲ್ಲಿ ಏನ್ ಮಾಡ್ಬೇಕು, ನಾವೇನ್ ಮಾಡ್ಬೇಕು. Then it was argued, sorry, you have not seen that amendment act, you see. We have seen, yeah, what is all this? 1 year minimum ಮಾಡಬೇಕಲ್ರಿ ನಾನು. Okay. Then luckily that offense was committed earlier to that date, December 87. Then learned judge said, Manjula Chalur, madam, just said this. Your accused is very, very luckily he has, you see, he is lucky enough being an accused. He said, you are lucky to have, because he is very intelligent accused, because you can leave him because it is prior to the amendment act. Because law says 88 Act amendment act says it is prospective. We all of us know the interpretation. Unless the amended act says retrospectively, it is deemed to be prospective. So charge sheet also filed earlier. Then rising of the court, learned judge said, no, we don't acquit him, we convict him until the rising of the court, pay some fine and all that, some amounts, finish off. That was, you're lucky, accused is very mischievously lucky, was the expression. That is our experience. Then heinous offenses anta barutte. Heinous offenses, I am telling you, ಎಂತ womanizing, ಅದು ಇದು ಅದನ್ನು ಇದೆಲ್ಲ ಸಿ ಅಂತವತ್ತಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಗೇನ್ ಸೈಡ್ 480 ಮೊನ್ನೆ ಯಾವುದೋ ಗಾಯತ್ರಿ ಅಂತ ಯಾವುದೋ ಕೇಸ್ ರಿಪೋರ್ಟ್ ಆಯ್ತು, ವೆರಿ ಲಾಸ್ಟ್ ಇಯರ್ ಆಗಿಲ್ಲ. ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ರು ಅಂತ ಅವರು, ನೀವು ನೀವು ಹೀನಿಯಸ್ ಅಫೆನ್ಸಸ್ ಸ್ವಲ್ಪ ಕೇರ್ಫುಲ್ ಇರಿ, ಸುಮ್ಮನೆ ನೀವು ಹಂಗ ಬೇಲ್ ಕೊಡೋದು 482 ಕೊಡೋದು ಮಾಡಬೇಡಿ. ಯಾಕಂದ್ರೆ ಬೇಲ್ ಕೊಟ್ರೆ 482 ಅಲೋ ಮಾಡಿದಂಗ, ಆಗ ಬೇಲ್ ಕೊಟ್ಟು ಮುಂದೆ ಏನಿರುತ್ತೆ ಹೋಗೋದನ್ನಿಲ್ಲ. ಬಟ್ 482 ಎಕ್ಸರ್ಸೈಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಕೂಡ ನೀವು ಬಿ ಕೇರ್ಫುಲ್, ಬಿಕಾಸ್ ಇಟ್ ಈಸ್ ಗಿವಿಂಗ್ ಬ್ಯಾಡ್ ಮೆಸೇಜ್ ಟು ದಿ ಸೊಸೈಟಿ. Be careful of Supreme Court regarding 482 as said at the case. Then comes up matrimonial disputes 498. Matrimonial disputes is no longer within the 4 corners of house ಆಗ್ತಾವ. ಅವರು ರಿಲೇಟಿವ್ಸ್ ಬಿಡ್ತಾರೆ, ಇದನ್ನ ಬಿಡ್ತಾರೆ. ಗಂಡ ಹೆಂಡತಿ ಒಪ್ಪಿಕೊಂಡ್ರೆ 482 ನಲ್ಲಿ ನಂಬರ್ ಆಫ್ ಮ್ಯಾಟರ್ಸ್ ಆರ್ ಕ್ವಾಶ್ಡ್ ಡಿಪೆಂಡಿಂಗ್ ಅಪಾನ್ ಸಿಚುವೇಶನ್, ಅವೇರ್ಮೆಂಟ್ಸ್ ಯಾವ ತರ ಮಾಡ್ತಾರೆ. Then comes up, friends, charge before charge, after charge ಏನು 482 ಕತೆ ಅಂತಾರೆ. ಬಿಫೋರ್ ಚಾರ್ಜ್ ಸ್ವಲ್ಪ ಲಕ್ಕಿ ಇರ್ತೀವಿ ನಾವು. ಆಫ್ಟರ್ ಚಾರ್ಜ್, ಆಫ್ಟರ್ ಫ್ರೇಮಿಂಗ್ ಆಫ್ ಚಾರ್ಜ್ ಏನಾಗ್ತದೆ, ಕಾನ್ಸೆಪ್ಟುಲಿ ಡಿಫರೆಂಟ್. ಬಿಕಾಸ್ when the charge is framed, ಅವಾಗ ಅದು judges may not feel it to be very happy to grant interim order or quash, because unless you so thoroughly that right from inception ಅದು offense ಆಗಿಲ್ಲ ಅಂತ you must boundaries ತೋರಿಸ್ತದೆ, ಆಗುದಿಲ್ಲಲ್ಲ. because charge is already framed ಅಲ್ಲ, you have to answer. ಮೊದಲಿಗೆ ಬರ್ಬೇಕಾಯ್ತು, ಮೊದಲಿಗೆ ಬಂದ್ರು ಒಂದ್ಸಲ ಆಮೇಲೆ ಬರ್ರಿ ಅಂದಿರ್ತಾರೆ. ಸೊ ಅದರಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಸೇಜ್ ಆ ತರ ಮಾಡೋದಿಲ್ಲ ಅಂತ ಹೇಳಿ ಎನಿ ನಂಬರ್ ಆಫ್ ಜಜ್ಮೆಂಟ್ಸ್ ಬಂದವು. ಎನಿ ನಂಬರ್ ಆಫ್ ಜಜ್ಮೆಂಟ್ಸ್. ಬ್ಯಾಂಕ್ ಮ್ಯಾನೇಜರ್ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಇರ್ತಾವ, ಬ್ಯಾಂಕ್ ಮ್ಯಾನೇಜರ್ ಕೇಸಸ್ ಇರ್ತಾವಲ್ಲಿ ಚಾರ್ಜ್. ಈ ಬ್ಯಾಂಕ್ ಮ್ಯಾನೇಜರ್, ಮೋಸ್ಟ್ ಆಫ್ ದ ಬ್ಯಾಂಕ್ ಮ್ಯಾನೇಜರ್ ಕೇಸ್ ಆರ್ ಆಲ್ ಈಸ್ ಕಂಡಕ್ಟಿಂಗ್ ಐದರ್ he has funds misappropriation, ಅಥವಾ he has granted loans ignoring the guidelines. If the value of the property is 17 lakhs, he has granted 19 lakhs, like that. There are some guidelines. ಅಲ್ಲೂ ಏನಾಗ್ತದೆ, ಅಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ಅವರು ಅಲ್ಲಿ ಕ್ವಾಶ್ ಮಾಡೋದಿಲ್ಲ ನಾರ್ಮಲಿ ಅವರು, ಯಾಕಂದ್ರೆ ಅದು ಅಫೆನ್ಸ್ ಹ್ಯಾಸ್ ಟು ಬಿ ವಿಜುವಲೈಸ್ಡ್ ಅಂತ ಹೇಳಿ. ದೇ 482 ನಾರ್ಮಲಿ ಮಾಡೋದಿಲ್ಲ. They will ask you to go to the trial, face the trial, nothing else. Then comes up malafide complaint ಇದ್ರೆ ಏನು. malafide complaint ಅಂದ್ರೆ ಏನು, ಈಗ ರಾಜಕೀಯ ಕಂಪ್ಲೇಂಟ್ ಇರ್ತಾವ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ, ಅವ ಮ್ಯಾಲೇನ ಬರ್ದಿರ್ತಾನೆ, ಹಿಂಗಾಗಿದೆ, ನಮ್ಮ ರಾಜಕೀಯ ಪಕ್ಷ ಹಿಂಗ್ ಒದರಾಡಿದ್ರೆ ನಾವ್ ಹಿಂಗ್ ಮಾಡಿದ್ದೀವಿ ಮತ್ತೆ ಮ್ಯಾಲಿಫಿಟ್ ಇದ್ರೆ ಕೋರ್ಟ್ ಭಜನ್ ಲಾಲ್ ಲಾಸ್ಟ್ದಲ್ಲಿ ಹೇಳಿದ್ರಲ್ಲ, ಇಫ್ ಇಟ್ ಮ್ಯಾನಿಫೆಸ್ಟ್ಲಿ ಅಟೆಂಡೆಡ್ ಟು ಇದ್ರೆ ಯು ಕ್ವಾಶ್ ಇಟ್ ಅಂತ. ದೇರ್ಫೋರ್ ಅಂಡ್ ಸಚ್ ಕುಕ್ಕಡಪ್ ಕಂಪ್ಲೇಂಟ್ ಅಂತೀವಿ ನಾವು, ಕಲರ್ಫುಲ್ ಕಂಪ್ಲೇಂಟ್ ಟು ಮೇಕ್ ದ tarnish the image of the person, that can be quashed. High Court can as well. Then for it in combination with Article 226 ಅಂತ ಒಂದು ಕಾನ್ಸೆಪ್ಟ್ ಬರುತ್ತೆ. ಈಗ ರಿಟ್ ಇಂಟು ಬ್ರಾಕೆಟ್ ನಾವು 482 ಅಂತ ಹಾಕೋತೀವಿ. ದಟ್ ಆಲ್ಸೋ ಈಕ್ವಲಿ ಅದು ಪೆಪ್ಸಿನಲ್ಲಿ ಕ್ಲಿಯರ್ ಮಾಡಿಬಿಟ್ರು. ಪೆಪ್ಸಿ AR 1998 ಸುಪ್ರೀಂ ಕೋರ್ಟ್ 128 ಅಲ್ಲಿ ಈಕ್ವಲೆಂಟ್ ಅಂತ ಮಾಡ್ಯಾರ. 227 226 ಎಲ್ಲ ಒಟ್ಟು ಆಗ್ತಾವ ನೀವು. ಬಟ್ ಡಿಪೆಂಡ್ಸ್ ಅಪಾನ್ ದಿ al veracity, how do you argue before the court, what compass you take, what the judge would take, that depends upon you. Then comes a friends, ultimately can you say that it is the court or the judge for court and judge ಅಂತ ಕೇಳ್ತಾರ. ಈಗ ultimately judge failing to exercise jurisdiction under 42, no, court would not entertain, which is the guideline. That question has also been answered in Ramesh Thapar case ಅಲ್ಲಿ. I think 2007 Supreme Court also said, ಅವ್ರು ಏನಂತಾರಂದ್ರೆ ನೋಡ್ರಿ, we go to the extent of only saying 482 ಪಿಟಿಷನ್ ಗೆ ಕೇಸ್ ನೀವು ಅಲೌ ಮಾಡಿದ್ದಕ್ಕೆ ಅದು ಎಷ್ಟು ಏನ್ ರೀಸನ್ಸ್ ಕೊಟ್ಟಿದ್ದೀರಿ. ಇಫ್ ಯು ಆರ್ ಹೈಲಿ ಸ್ಯಾಟಿಸ್ಫೈಡ್ ದಟ್ ಕೇಸ್ ಡಸ್ ನಾಟ್ ಡಿಸರ್ವ್ ಟು ಬಿ ಪೆಂಡಿಂಗ್, ಇಫ್ ಇಟ್ ಇಸ್ ಇಟ್ ವುಡ್ ಎಂಡ್ ಇನ್ ಅಕ್ವಿಟಲ್, ಇಫ್ ಇಟ್ ಇಸ್ ರಿಯಲಿ ಅಬ್ಯೂಸ್ ಆಫ್ ಪ್ರೊಸೆಸ್ ಆಫ್ ಲಾ ಇದ್ರೆ, ಇಫ್ ಇಟ್ ಹಿಂಡರ್ಸ್, ಇಫ್ ಇಟ್ ಟೋಟಲ್ ರೈಟ್ಸ್ ಆಫ್ ಪರ್ಸನ್ ಆರ್ಡಿನರಿ ಮ್ಯಾನ್ ಶುಡ್ ನಾಟ್ ಸಫರ್, ಅದಿದ್ದೇ ಕೊಡ್ತೇವೆ. ಆದ್ರೆ ನಮಗ ಅದನ್ನ ನೀವು ಮಾಡಿದ್ರೋ ಇಲ್ಲೋ ಅಂತ ನಾವು 482 ಕೊಡ್ಲಿಕ್ಕೆ ಆಗುದಿಲ್ಲ ಅಂತ. ವೆದರ್ ಪ್ರೊಸೀಜರ್ ಅಡಾಪ್ಟೆಡ್ ಬೈ ಯು, ವಾಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಯು ಹ್ಯಾವ್ ಸೀನ್, ವಿಲ್ ಓನ್ಲಿ ಸಿ. Thereafter, after allowing it, now we don't exercise because it is not our Supreme Court cannot do all that. It is High Court work. They will say only what is done is right or wrong. Is coin idರಲ್ಲಿ coin ಹಾಕಿದಂಗ ಅದು ಇದು ಮೆಟ್ರೋ ಇದ್ರಲ್ಲಿ ಹಾಕಿ ನಾವು ಬಂದು ಬರ್ತಾರೆ ಹೋಗುತ್ತೆ. ನಾವೇ ಇಲ್ಲೆಲ್ಲ ನಾವು ನೋಡ್ಕೊಂಡು ನಾವೇ ನೋಡ್ಕೊಂಡು ಮಾಡೋದಿಲ್ಲ. ರೀಸೆಂಟ್ಲಿ ಹೇಳೋದು ಸೆಟ್ಲಿ. Then to secure the ends of justice, situation demands ಅಂತ ಹೇಳ್ತೀವಿ. Looking to the family of situation, health, ಓವರ್ ಸಿಚುವೇಶನ್, ಸೊಸೈಟಿನಲ್ಲಿ ಸ್ಟೇಟಸ್. ಹೊರಗಡೆ ಯಾವ್ದೋ ಒಬ್ಬ ಆರ್ಮಿ ಆಫೀಸರ್ ಪಾಪ ಅವ್ರು ಹೇಳಿದ ಆರ್ಮಿ ಆಫೀಸರ್ ಸುಮ್ಮನೆ ತಂದು ಕೊಡ್ತೀವಿ ಇಲ್ಲ ರೀ ಎಷ್ಟ್ರಿ ಅವ್ದು ಪಾಪ ಅವ್ನು ಕೋಟ್ ಹಾಕೊಂಡು ಕಲರ್ ಕೋಟ್ ಹಾಕೊಂಡು ಫ್ಲೈಟ್ ನಾಗ ಅಡ್ಡಾಡ್ತಾನೆ, ಏನ್ ಮಾಡ್ದಂಗ ಪಾಪ ಎಲ್ಲಿ ನೀವು ತರ್ತೀರ ಅವ್ರು ವೇರ್ ದೇರ್ ನೋ ಮೆಟೀರಿಯಲ್ ಎಟ್ ಆಲ್, ವೈ ಟು ಟ್ರಾವೆಲ್ ಅಂತ ಕ್ವಾಶ್ ಮಾಡ್ಯಾರ. ಅದೇ ಆಡಿಟ್ ವರ್ಡ್ ಅದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ ಹೋಗಿ ಅವ್ರು ಮಾಡ್ಯಾರ. ಮತ್ತದ್ ಅಂದ್ರೆ ಮಾಡಿದ್ರು ಕನ್ಫರ್ಮ್ ಇಲ್ಲ ರೇ ಗೊತ್ತಾಗ್ತದ್ರಿ ಲೈವ್ ನಾಗ ಯಾವ ಮನುಷ್ಯ ಏನೋ ಸ್ಟೇಟಸ್, ಅವ್ನು ಎಜುಕೇಶನ್ ಡಬಲ್ PhD ಹೋಲ್ಡರ್ ಸುಮ್ಮನೆ ಅವ್ನು ಅಡ್ಡಾಡ್ಸ್ತಾರೆ. No, don't do all this. We know what is going. There are two things, objective and subjective. Objective means subjective and go into his mind and see. Yeah, ಯಾಕೆ ಮಾಡ್ತಾನೆ offense? ಅವನಿಗೆ benefit ಇಲ್ಲ ಅದರಿಂದ ಪಾಪ. What's it? Question. Then the pronouncements of High Court and Supreme Court precedent ಬಗ್ಗೆ any number of judgments. I need not emphasize over all that. But ಈಗ ಇನ್ನು judgments ಬಗ್ಗೆ ನಾವು ಹೇಳೋದಾದ್ರೆ ಅದೇ ಪೆಪ್ಸಿ ಫುಡ್ಸು, ದೆನ್ ಭಜನ್ ಲಾಲು, ದೆನ್ ರಾಜೀವ್ ಥಪ್ಪಾರ್, ದೆನ್ ಜಂಡು ಫಾರ್ಮೆಟಿಕಲ್ಸ್ ಒಂದು ಕೊಟ್ಟರು. ಅದೇ ಯಾವ್ದೋ ಒಂದು ಅದರಲ್ಲಿ ಒಂದು ಏನೋ ಒಂದು ಕುಡಿಯಕ್ಕೆ ಒಂದು ಇದನ್ನ ಕೊಟ್ಟಿರ್ತಾರೆ, ಏನೋ ಒಂದು ಲಿಕ್ವಿಡ್ ಏನು ಕೊಡ್ತಾರೆ, ದಟ್ ಅದು ಕಂಟಾಮಿನೇಟೆಡ್ ಮೊನ್ನೆ ಅಂತ ಕೇಸ್ ಹಾಕ್ತಾರೆ. ಅವ್ರೇನಂತ ಯಾರ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಡೋ, ಹಿ ಇಸ್ ನಾಟ್ ದ ಪರ್ಸನ್, ಅವ ಡೀಲರು ಅಲ್ಲ, ಎರಡೂ ಅಲ್ಲ, ಮ್ಯಾನುಫ್ಯಾಕ್ಚರರು ಅಲ್ಲ, ತಗೊಂಡ್ ಹೊಂಟವ್ನು ಹಿಡ್ಕೊಂಡ್ರೆ ನಾಟ್ ಇಸ್ ಅ ಗುಡ್ ಕೇಸ್ ಟು ಕ್ಯಾಶ್. ಜಂಡು ಫಾರ್ಮೆಟ್ 2005 ಕೋರ್ಟ್ ಪೇಜ್ 9 ಅಲ್ಲಿ ಬರ್ದ್ರು ಅದನ್ನ. ಅಲ್ಲ ವಿಜಯ ಸಾರಥಿ ಅಂತ ಕೇಸ್ ಬರೆದ್ರು. ನೋ ಡೋಂಟ್ ಬುಕ್ ಕಿಸ್ ಎವ್ರಿ ಪರ್ಸನ್ ಫಾರ್ ಕ್ರಿಮಿನಲ್ ಕೇಸಸ್, ಪ್ಲೀಸ್ ಚೆಕ್ ಅಪ್ ಟ್ವೈಸ್, ಬಿಕಾಸ್ ವೆನ್ ಯು ಆಸ್ಕ್ ಎ ಪರ್ಸನ್ ಟು ಕಮ್ ಟು ಕೋರ್ಟ್ ಸಮನ್ಸ್ ಅಕ್ಯೂಸ್ಡ್ ಆದ್ರೆ ಯು ವಿಲ್ ಲೂಸ್ ಇಸ್ ಇಮೇಜ್ ಹೋಗ್ತದೆ, ಪಾಪ ಜಾಬ್ ಸಿಗಲ್ಲ, ಇದಾಗಲ್ಲ, ಪೆಂಡಿಂಗ್ ಆಫ್ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಯು ವಿಲ್ ನಾಟ್ ಗೆಟ್ ಜಾಬ್ಸ್ ಆಲ್ಸೋ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅನಲೈಸ್ ವೆರಿ ಮಚ್. ಅಂಡ್ ದೆನ್ ಲಲಿತ್ ಕುಮಾರ್ ಅಂತ ಇನ್ನೊಂದು ಆಸ್ಪೆಕ್ಟ್ ಬರುತ್ತೆ. ಈಗ FIR 154 ಅದೇ ಹೇಳ್ತಾ ಹೋದ್ರೆ there is no 482 ಮುಗಿಯೋದನ್ನ ಇಲ್ಲಿ ಏನ್ there is no end at all. ಲಲಿತ್ ಕುಮಾರ್ ಇದರಲ್ಲಿ whenever a message comes to the police through somebody whatever competent ನಿಮ್ಗೆ ಅದು ಬೇರೆ, police is expected to register the FIR then go for investigation. ಇಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ, ಮೊದ್ಲೇಕನ ಒಂದ್ ವಾರ ಎಲ್ಲ ಮಾಡಿ ಇನ್ನು ಅಮ್ ತಗೊಂಡು ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತಾರೆ. ಲಲಿತ್ ಕುಮಾರ್ ಇಸ್ ನೋ, ಇಟ್ ಕಾಂಟ್ ಬಿ ಡನ್. ಬಟ್ ಈಗ ಲೇಟೆಸ್ಟ್ ಲಲಿತ್ ಕುಮಾರ್ ಇಸ್ ಕೇಸ್ ಅಗೇನ್ ಹ್ಯಾಸ್ ಬಿನ್ ಬಿಫೋರ್ ಟು ಲಾರ್ಜರ್ ಬೆಂಚ್. ವಿ ಬಿಲೀವ್ ಅದೇನಾಗ್ತದೆ, ಜಡ್ಜಸ್ ಅವಾಗ ಏನ್ ಮಾಡ್ತಾರೆ, ತಡ್ರಿ ಲಲಿತ್ ಕುಮಾರ್ ಸಬ್ಜೆಕ್ಟ್ ನಮ್ಗೆ ಹೇಳ್ಬೇಡ್ರಿ, ಪ್ಲೀಸ್ ಟೆಲ್ ಯುವರ್ ಕೇಸ್. ಇಫ್ ಇಟ್ ರಿಯಲಿ ಪ್ರಿಕ್ಸ್, ನಮ್ದ್ರಲ್ಲಿ 42 ದಿವಸ ಎಲ್ಲಾ ಮಾಡಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದ, ಕೋರ್ಟ್ ಕ್ವಾಶ್ ಇಟ್, ಮತ್ತೆ ಯಾಕೆ ವೇಟ್ ಮಾಡ್ತೀವಿ, ಬಿಡ್ರಿ ಇನ್ನೇ ವೈಡ್ ವೇಟ್ ರೀಜನ್ ಬೆಂಚ್ ಏನು ಇಲ್ಲ, ಬಿಕಾಸ್ ಇಟ್ ಇಸ್ ವೆರಿ ಕ್ಲಿಯರ್ ಟು ದ ನೆಕೆಡ್ ಐಸ್. 40 ಅವನ ಬರ್ದಾನ, ಹಿಂದಿನ ದಿವಸ ಹೋಗಿ ಎಲ್ಲ ಮಾಡಿ ಇದನ್ನ ಮಾಡಿ ಇವತ್ತಿನ ದಿವಸ ಕಂಪ್ಲೇಂಟ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಲಾಗಿದೆ. ದಟ್ ಇಟ್ಸ್ ಲಲಿತ್ ಕುಮಾರ್ ಕಾಂಟ್ರಿ, ಬಿಕಾಸ್ ನಮ್ಗೆ ಡಿಫೆನ್ಸ್ ಉಳಿಲಿಲ್ಲ, ವಾಟ್ ಎಲ್ಸ್ ಯು ಕ್ಯಾನ್ ಡು. ದೆನ್ ನಿಹಾರಿಕಾ ಅಂತ ಬರೋದು ಹೇಳಿದ್ನ, ನಿಹಾರಿಕಾದಾಗ ಅವ್ರು ಏನಂತಾರ, ನೀವು ಅವ್ರ ವರ್ಡ ಯೂಸ್ ಮಾಡ್ಯಾರ, ಫಾರ್ ಫ್ಯಾಷನ್ ಸೇಕ್ ಮಾಡಬೇಡ್ರಿ, ಅನ್ಲೆಸ್ ಡಿಸರ್ವಿಂಗ್ ಕೇಸ್ ಇದ್ದು ಮಾಡಿ. ಉಷಾ ಚಕ್ರವರ್ತಿ ಕೇಸು, ಮಾಧವರಾವ್ ಸಿಂಧಿಯಾ, ಎನಿ ನಂಬರ್ ಆಫ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಆರ್ ದೇರ್ ಅಂತ. ಸೊ ಗಯಾನ್ ಸಿಂಗ್ ಕೇಸು ಕಂಪೌಂಡಬಲ್, ಎನಿ ನಂಬರ್ ಆಫ್. ಈಗ ನೋಡ್ರಿ ಮತ್ತೆ ಅದೇ ಈಗ ನೋಟ್ರೀಸ್ ಐ ಟೋಲ್ಡ್ ನೋಟ್ರೀಸ್ ಕೇಸಲ್ಲಿ ಸುಕೇಶ್ ಕೇಸು, ಸೀಡ್ಸ್ ಆಕ್ಟ್, ಎಸೆನ್ಸಿಯಲ್ ಕಮಾಡಿಟೀಸ್ ಅಂತೂ ಮೋಸ್ಟ್ ಇಂಟ್ರೆಸ್ಟಿಂಗ್. ಈಗ ಡೇ ಟು ಡೇ ಪೇಪರ್ ಅಲ್ಲಿ ನೋಡ್ತಾ ಇದೀವಿ 200 bags ಕರೆಕ್ಟ್ ರೀ, ಪ್ರೊಸೀಜರ್ ಫಾಲೋ ಮಾಡುದಿಲ್ಲ. 200 bags ಕರೆಕ್ಟ್. ಮೇಲ್ನೋಟಕ್ಕೆ ಅದು ಏನಂದ್ರೆ ಪಡಿತರ ಅಕ್ಕಿ ತರ ಇದ್ದದ್ರಿಂದ ಕೇಸ್ ಕಂಪ್. ಮೇಲ್ನೋಟಕ್ಕೆ ಯಾವಾಗ ಬರ್ತದ ರಿಪೋರ್ಟ್ ಕಳ್ಸೋದು, ಆಮೇಲೆ ಮೇಲ್ನೋಟಕ್ಕೆ ಯಾರಿಗೆ ಗೊತ್ತಾಗ್ತದೆ? ದುರ್ಬಿನ್ ಹಿಡಿದು ನೋಡಿದ್ರೆ ಕೋರ್ಟ್ ಇಸ್ ಇಲ್ಲ ರೀ. ಮತ್ತು ಇನ್ಕಾಂಪಿಟೆಂಟ್ ಪರ್ಸನ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತಾನೆ, ಪೊಲೀಸ್ ಕೊಟ್ಬಿಟ್ಟು ಡಿವೈಸ್ ಕೊಟ್ಟಿರ್ತಾನೆ, ಅವ್ರಿಗೆ ಅಧಿಕಾರ ಇಲ್ಲ. ಸೊ ಪೋಸ್ಕೋ ಕೇಸು ಎಟ್ ಅನದರ್ ಇಂಟ್ರೆಸ್ಟಿಂಗ್. ನೋಡಿ ಪೋಸ್ಕೋ ಕೇಸಲ್ಲಿ ಏಜು ಪಿರಿಯಡ್ ಅಂಡರ್ಗಾನ್, ಎಷ್ಟು ಹೋಗ್ಯಾನ, ಎಲ್ಲಿ ಹೋಗ್ಯಾನ, ಏನ್ ದೇರ್ ಆಲ್ ದಿ ಸಿಚುವೇಶನ್ಸ್, ದೇರ್ ಆಲ್ ಟ್ರಿವೆಲ್ ಅರೌಂಡ್ ಒನ್ ಆಫ್ಟರ್ ಅದರ್. ಇವೆಲ್ಲ ಸಿಚುವೇಶನ್ಸ್. ಅದೇ ಈ ಕೆಲವೊಂದು ಒಂದೇ ಇಷ್ಟು ಏನಂದ್ರೆ ಎವ್ರಿ ಅಫೆನ್ಸಿವ್ ಒಂದು ಇಂಪಾರ್ಟೆಂಟ್ ಇರ್ತದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಡಿಸಾನೆಸ್ಟ್ ಇಂಟೆನ್ಷನ್ ಅಲ್ಲೇ ಬುದ್ಧಿ ಅಂತ ಇರಬೇಕು, ಮರ್ಡರ್ ಡೆತ್ ಇರಬೇಕು, ಪ್ರಪೌಂಡೆಡ್ ಪ್ರಿಪೇರ್ಡ್ ಇದು, ಥೆಫ್ಟ್ ವಿದೌಟ್ ಇಸ್ ಕನ್ಸೆಂಟ್ ರಿಮೂವಿಂಗ್ ದ ಮೂವಲ್ ಪ್ರಾಪರ್ಟಿ, ಡಿಫಮೇಷನ್, ರೂಲಿಂಗ್ ಇಸ್ ರೆಪ್ಯುಟೇಷನ್. ಒಂದು ಅಂದ್ರೆ ನನ್ನ ಪ್ರಕಾರ ಒಂದು ಕೇಸ್ನಲ್ಲಿ ಒಂದೋ ಎರಡೋ ಟ್ರಿಕಿ ಇರ್ತಾವ, ಅದರಲ್ಲೇ ವೆ ಟು ಫೈಟ್. ಫರ್ಗೆಟಿಂಗ್ ದ ಲಾ ಆಸ್ಪೆಕ್ಟ್ ಇಸ್ ಅಗೇನ್ ದಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ. SC/ST ಅಟ್ರಾಸಿಟೀಸ್ ಇದೆ ಎಷ್ಟು, ಅದರಲ್ಲಿ ನಂಬರ್ ಆಫ್. ಈಗ ವೆದರ್ ಹಿ ಬಿಲಾಂಗ್ಸ್ ಟು ಇನ್ ಒನ್ ಕೇಸ್, ಎಷ್ಟು ವಿಚಿತ್ರ ಕೇಸ್ ವೆಂಟ್ ಆನ್ ಫಾರ್ ಏನು ಒಂದು 7-8 ವರ್ಷ ನಡೀತು. ದೆನ್ ಒನ್ ಫೈನ್ ಡೇ ಜಡ್ಜ್ ಸೆಡ್ ಆಲ್ರೆಡಿ ದಿಸ್ ಫೆಲೋ ಆಲ್ಸೋ ಬಿಲಾಂಗ್ಸ್ ಟು ಸೇಮ್ ಕಾಸ್ಟ್. ತಗೊಳ್ರಿ ಇವ್ರ, he has expected to know the cost of the complaint, cost of the accused. ನೋಡಿ ಎರಡು ನೋಡಿಲ್ಲ, ಏನ್ ಕೇಸ್, ವಾಟ್ ಇಸ್ ಆಲ್ ದಿಸ್? therefore ಇದು ನಾ ಯಾಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅಂದ್ರೆ, ಏನ್ ನಾವು ಭಾಷಣಕ್ಕೋಸ್ಕರ 482 has really serious situations, serious consequences before the court. But as a lawyers ನಮ್ಗೆ ಏನು ಅಂದ್ರೆ, our job is to seek that, to see that it does not come under the definition of that. There is an exception, there is a wrong, injustice, security of justice. ಇದೇ ಕೋಟದಲ್ಲೇ ಮತ್ತೆ ನಾವು we are bound to lodge about that. ಇದನ್ ಬಿಟ್ರೆ there is nothing else that can be sought out. more recent 2023 ನಲ್ಲಿ ಅದೇ ಉಷಾ ಚಕ್ರವರ್ತಿ ಕೇಸಲ್ಲಿ ಹೇಳಿದ್ನಲ್ಲ, ದೇರ್ ಲಾರ್ಡ್ಶಿಪ್ ಜಸ್ಟಿಸ್ ಅಜಯ್ ರೋಹಿಷ್ಗಿ ಮತ್ತು ರವಿಕುಮಾರ್ ಸಾಹೇಬ್ರು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸೆಡ್. ಮತ್ ನೋಡ್ರಿ ಇಲ್ಲಿ ಮತ್ತೆ ರಿಪೋರ್ಟರ್ ಏನಂತಾರೆ, ನೀವು ಸಿವಿಲ್ ಲಿಟಿಗೇಷನ್ಸ್ ಇಟ್ಕೊಂಡು ಅದನ್ನು ಇಲ್ಲಿ ಕೂಡ್ಸ್ಕೊಂಡು ಇದನ್ನು ಸೇರಿಸ್ಕೊಂಡು ಸಿವಿಲ್ ಲಿಟಿಗೇಷನ್ ಸೂಟ್ ಕೇಸ್ ಇದ್ದದ್ದು ಕಂಪ್ಲೇಂಟ್ ನಾಗ ಬರ್ದ್ರು ಕೋರ್ಟ್ ಏನ್ರಿ ವಾಟ್ ಇಸ್ ದಿಸ್? ನೋ ವಿ ಮಸ್ಟ್ ಟೇಕ್ ಕೇರ್. 482 ಅವಾಯ್ಡ್ ಮಾಡಿ, 482 ಅವಾಯ್ಡ್ ಮಾಡ್ರಿ ಅಂತ ನಾವು ಹೇಳಿಲ್ಲ, ಬಟ್ 482 ಚೆಕ್ಅಪ್ ಮಾಡ್ರಿ. ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇದ್ದು ಪೆಂಡಿಂಗ್ ಇದ್ದು ಅದು ಡಿಗ್ರಿ ಆಗಿ ಅಪೀಲ್ ಹಾಕೊಂಡು ಇನ್ನೊಂದು ಕೇಸ್ ಹಾಕ್ಯಾನ, ಇಂಜೆಕ್ಷನ್ ಇದೆ, ಮತ್ತೆ ಇಲ್ಲಿ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ತಾರೆ. latest Supreme Court judgment. Therefore, friends, these are all the various, according to me, there is no end to this. Idu 482 is such a large subject that no one can see. There is no end to this. It is only a beginning, I believe. There is no end at all. It is as good. If I am to talk, I believe I am learning this, not talking about knowledge already, because I want to extract so many things from you also. ಈಗ law how this 482 has developed. ಈ ನೀವು ಅದನ್ನ ಇದನ್ನ ನೋಡಿದ್ರೆ ಅದ್ರದ್ದು ವಾಟ್ ಯು ಕಾಲ್ as ನೀವು ಸ್ಕೋಪ್ ಅಂಡ್ ಸಿನಾಪ್ಸಿಸ್ ಅಂತ ನಾವು ಸೆಕ್ಷನ್ ಅಲ್ಲಿ ತೆಗೆದ್ರೆ 482 ತೆಗೆದ್ರೆ 297 ಆಗ್ಯಾವ ಲೇಟೆಸ್ಟ್ CRPC. ಐ ಆಮ್ ವಂಡರಿಂಗ್ ಎಷ್ಟು ಸಿಚುವೇಶನ್ಸ್ ಅಪ್ಪ ಇದು. ಒನ್ ಆಫ್ಟರ್ ದಿ ಅದರ್. ಏನು ಆಬ್ಜೆಕ್ಟ್ ಅಂಡ್ ಸ್ಕೋಪ್, ಸಮರಿ ಆಫ್ ಟ್ರಯಲ್, ಜಸ್ಟ್ ಅಂಡ್ ಪ್ರಾಪರ್ ಅಂದ್ರೆ ನಥಿಂಗ್ ಇನ್ ದಿಸ್ ಶಾಲ್ ರಿಮೆಂಟ್. ಹಾಗೆ ಒಂದು ಬಿಡಿಸಿದ್ರೆ ಎನಿ ನಂಬರ್ ಆಫ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್, ಅಂಡ್ there is no end to this. You see what type of any case is a new case according to Belaku. Judge is expected to see that case, forgetting the law, then come to the law, then see both. That's all. Therefore, my friend, this is all that I wanted to emphasize before you, rather than it is a learning than talking what I believe. I only shared my thoughts for section 482, and Basavaraj has provided me an opportunity to address the gathering. I should thank him really that he has permitted me to, throw my thoughts over this gathering. Basavaraj sir?
Yes, sir. Yes, sir.
Sir, did I?
The kind of preparation, the kind of meticulous work, and the enormous knowledge which you possess is reflected in the magnificent speech you delivered today, sir. I must congratulate you, and I really envy your the vast knowledge which is at your command. So ಈ ಪ್ರಶ್ನೋತ್ತರ ಕಾರ್ಯಕ್ರಮ ಇದೆ. ತಾವ್ ಯಾರಿಗಾದ್ರೂ ಪ್ರಶ್ನೆಗಳನ್ನ ಕೇಳ್ತಕ್ಕಂತ ಅವಶ್ಯಕತೆ ಇದ್ರೆ
ನಮ್ಗೆ ಗೊತ್ತಿದ್ರೆ ಹೇಳ್ತೀವಿ ಅಷ್ಟೇ. ನಮಗ್ ಗೊತ್ತಿದ್ರೆ ಹೇಳ್ತೀವಿ. ಯಾಕಂದ್ರೆ 482 ಒಂದು ಪ್ರಶ್ನೆ ಅನ್ಕೋಬಹುದು ನೀವು.
ಪ್ರಶ್ನೆಗಳನ್ನ ಕೇಳ್ತಕ್ಕಂಥವ್ರು ತಾವು
Humor.
ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡು ಪ್ರಶ್ನೆಗಳನ್ನ ಕೇಳ್ಬೋದು. ಇವತ್ತು ಇನ್ನೊಂದು ಕಾರ್ಯಕ್ರಮ ಇದೆ NGO ಹಾಲ್ ನಲ್ಲಿ, ಬಹುಶಃ ಅಲ್ಲಿ ಸುಮಾರು ಜನ ಹೋಗಿದ್ದಾರೆ ಅಂತ ಕಾಣಿಸುತ್ತೆ. ಇದನ್ನ ನಾನು ಯೂಟ್ಯೂಬ್ ನಲ್ಲಿ ಪ್ರಚಾರ ಮಾಡ್ತೇನೆ, ತಾವು ದಯವಿಟ್ಟು ಎಲ್ಲ ನೋಡ್ಬೇಕಾಗಿ ನನ್ನ ಪ್ರಾರ್ಥನೆ. ಸೊ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು ಮತ್ತು ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ ಲಾ ಅಕಾಡೆಮಿ ಪರವಾಗಿ ನನ್ನ ಕಡೆಯಿಂದ ಮತ್ತು ಕರ್ನಾಟಕದ ಎಲ್ಲ ವಕೀಲರ ಪರವಾಗಿ ತುಂಬು ಹೃದಯದ ಧನ್ಯವಾದಗಳನ್ನ ಶ್ರೀ SP ಕುಲಕರ್ಣಿ, ಹಿರಿಯ ವಕೀಲರು ಕರ್ನಾಟಕ ಇವರಿಗೆ ಅರ್ಪಿಸುತ್ತಾ ಇದ್ದೇನೆ. ಮತ್ತೊಮ್ಮೆ ಬೆಳಕು ಉಪನ್ಯಾಸ ಮಾಲಿಕೆಯಲ್ಲಿ ಮತ್ತೊಂದು ವಿಚಾರವನ್ನ ತೆಗೆದುಕೊಂಡು ಉಪನ್ಯಾಸವನ್ನ ಮಾಡ್ಲಿಕ್ಕೆ ನಾವು ಬರ್ತಾ ಇದ್ದೇವೆ. ಅಲ್ಲಿವರೆಗೂ ತಮಗೆಲ್ಲರಿಗೂ ಧನ್ಯವಾದಗಳು. ಶುಭರಾತ್ರಿ. ಥ್ಯಾಂಕ್ ಯು.
Very kind of Basuras. Very, very happy.